I'm sorry.
Do what? See you got the back. What? Bring him out. What's his name? Commonwealth versus Robert Tabor. Welcome, Judge.
We are completing the plea paperwork at this time. If you could recall this case, that would be okay.
How much room do we have back there? Yeah, well, the problem is you're taking up all the space. How much time are you gonna need?
We just started preparing, so 5 or 10
Okay,
minutes.
let me ask you again, how much time are you?
5 minutes
I won't
minimum.
rush you. I have to do some planning here, okay?
5 to 10 minutes, Your Honor.
Okay, that'll be fine. Commonwealth versus Terry Aaron. Morning. Are you Terry Aaron?
Yes, sir.
Good morning. We're here on 25 CR 0081. Is your year of birth 1987? Last 4 digits of your social security number 6691.
Yes, sir.
Mr. Stockton, what do y'all have here?
Well, I think this was a review from last month. He had a new felony arrest in Medford County where he had a bag of meth.
Yeah.
And we had him assessed for specialty court. My understanding is he's eligible.
Well, Judge, I mean, we'd like for him to be eligible or able to participate in drug court, specialty court, as in lieu of revocation.
Yeah, I guess we just need to find out from Mr. Murphy when the orientation date will be.
Are you ready to give it a real shot, Mr. Aaron?
Yes, sir.
Okay, well. We'll, go, have I signed the order yet?
For your report.
Yeah.
He's not order required, so.
Yeah, so we haven't heard, they hadn't voted. Well, did they vote this morning, did they, you know?
Well, we had to leave. I don't know if they voted or, yeah, he said there was 3 eligible when they voted, but he didn't mention the names, is what I recall. So I guess he was voted in. Nobody was rejected.
Okay, okay. Well, we'll wait to the orientation day and you'll get out that day for orientation.
We'll take Ms. Thompson with the date, so.
Okay, it'll be fine. You'll let him on the back row there so he won't have to walk over, let him go all the way to the end of the back row. Di and Cherry. Are you Mr. Cherry? Good morning. This is 26 CR 0013. Mr. Cherry, were you born in 1991?
Yes, sir.
Last 4 digits, what are the last 4 digits of your social security number?
9680.
Do what?
9680.
9680. You here for pretrial conference? What does the Commonwealth have to say?
Your Honor, we also have a motion for release of medical records on the children, I think at Monroe County Medical Center. Yeah, I'd ask that be signed, and once we get those records, we'll be ready for trial. I don't know if the court wants to go ahead and set a trial. It shouldn't take us long to get those records.
You have no objection to sign it?
No objection to the order. Judge, I would ask to set this over for negotiation. I'm still hopeful, that we can find some point in the middle here.
Yeah, sign the order. You want to save for negotiation date?
Well, August the 14th, August 14th at 9 a.m. And if we don't have a resolution next motion day, I'll ask for a trial day.
August the 14th, and the next court date be August 27th. Okay. Okay. Heather Edens. Commonwealth versus Heather Edens, 26 CR 0038. Are you Heather Edens?
Yes.
You born in 1973? Last four digits, social security number 5720. You here for a pretrial conference on 26 CR 0038. What's the Commonwealth have to say?
I just kind of waiting on the defense counsel on this case, Your Honor, see if there's any requests or any testing.
Well, I think there's several things that are probably still outstanding, gunshot residue. I think there's some, missing, there might be another report, somebody off were involved. I think there's some reports that we might not have yet. There, I'm sure are some medical records. It's quite early in a case of this magnitude. So I don't know.
What
whether we-
steps are you taking to get any of those? Have you filed motion for discovery or anything? Have you- With any particular?
Well, no, I think those things are the things the Commonwealth are gonna provide in discovery as they get them. I'm not.
What is there
I'm not believing-
outstanding, Mr. Sutton?
Yeah, I agree with Mr. Sheffield. There's a gunshot residue. There may be a supplement for officer. I'd have to look and see about
I
that.
forget, I just read through it yesterday and it
If you-
referenced that officer's report and I didn't see that officer.
If you could set this for negotiation, also, Mr. Sheffield and I can discuss any discovery issues and see where we're at.
August 14th for negotiation and discovery advancement, and then August 27th at the next pretrial, okay? James Flowers.
Let me go out and get his attorney, Your Honor. He actually don't know, so we do that. Here. Sure.
You're in on the Zoom call.
Tell him come on in here and get off the Zoom call, okay? Sorry for inconveniencing him.
Morning, Judge.
Good morning. Are you James Flowers?
Sir.
You born in 1975?
Yes, sir.
Last four digits, social security number 7390.
So
We're on 26 CR 0090 and 26 CR 0031 for sentencing. You get an opportunity to look at the pre-sentence investigation report, no probation parole. Is it substantially correct?
Yes, sir.
Is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On a plea of guilty possession of controlled substance, first degree case number 26 CR 0031, the defendant shall receive a sentence of 1 year. On a plea of guilty to operating motor vehicle under the influence of other substance, he shall receive a sentence of 5 years. That's 26 CR 0024. or plea of failure to maintain the insurance in motor vehicle in case 26 CR 0 to pay a fine of $500 plus court costs. The two sentences shall run consecutively for a term of 6 years. Serve 120 days probated for 5 years probation. Be supervised. What's the court cost?
The road cases together, 1,400.
Can you need some time to pay that? I'll let you pay it in $100 a month. First payment being 30 days from today. And when you pled guilty to these felonies, you knew they were enhanceable, correct? And the DUI is enhanceable. You knew that also, correct? You get another DUI.
Yes, sir.
Okay. How many days does he have in?
70, Your Honor.
How many?
70.
He's got 15 more days. Okay. Thank you very much. Jason Grider. Jason Grider. Joseph. Jason Grider.
It's Joseph, I think.
It's on your docket wrong. Comma versus Joseph Grider. You are Joseph Grider, born in 1982. What are the last four digits of your social security number?
9076.
9076. We're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report? Is it substantially correct?
Yes, sir.
Counselor, is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
On plea of guilty to possession of controlled substance, first degree, first offense, the defendant shall receive a sentence of 3 years, probated for 3 years. He agrees to enroll in the specialty court. Was he voted in this time or last time, or do you know, Mr. Stock?
I believe he was voted in. We sent Ms. Thompson the orientation day.
On a plea of guilty to operating motor vehicle under the influence of controlled substance, other substance, offender shall pay a fine of $500. Defendant shall receive credit for time served, have gainful employment, other conditions. Now, when you pled guilty to these things, you understood they were enhanceable, is that correct?
Yes, sir.
We got a voice activated thing and it has to speak. Yeah, man, on the DUI, it's the same thing. You knew it was enhanceable if you get another DUI, correct?
Yes, sir.
Okay, well, what's the total court costs?
$1,095.
You need some time to pay that?
Yes, sir.
Yeah, I'll let you pay it $100 a month, first payment, being due 30 days after you get released, okay? Dustin Hayes. Commonwealth versus Dustin Hayes, 21 CR 00138 and 26 CR 0037. You are Dustin Hayes.
Sir.
You're born in 1986.
Sir.
Last four digits, social security number 7836. Is that correct? Mr. Stockton, what do y'all have on this case?
We have a felony plea, Your Honor, to go along with the revocation.
A motion, I've just been informed that a motion has been submitted, and decision wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person we just identified in 21 CR 00138 and 26 CR 0037?
Yes, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Sir.
Is your judgment impaired today in any way?
No, sir.
Have you viewed the evidence Commonwealth has against you, believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can take a plea, I need to go over those rights and I'll ask if you understand. Anytime during this, any questions, step away, that's your turn. You have a right not to testify against yourself. No one can make you say anything. Your right to speed trial, but your right to be represented by counsel at your jury trial. The right to confront and prosecute all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand it, and guilty plea that you give up hard. You understand that? I may consider the Commonwealth's recommendation, but I may apply your range of provide by law. I don't have to accept the recommendation prior to looking at the recommendation. I'll await a pre-sentence investigation report to be done with probation parole in the event that I decide not to accept the recommendation. It's a harsher sentence. You have a right to withdraw your plea and go to trial. Do you understand that? Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of controlled substance, first degree, second offense, the defendant shall receive a sentence of 3 years, probated for 3 years. Probation is to be supervised. The defendant shall enroll and complete a long-term rehabilitation center. This sentence is to run consecutively to Cumberland Circuit Court Case Number 21 CR 138. The defendant shall pay court costs at the discretion of the court. The defendant shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky.
Is that what you agree to?
Yes, sir.
You're pleading guilty because you did commit the acts charged in the indictment, correct? Okay, yeah, you're doing so your own free will. You know your constitutional rights, you're waiving them and allow the court to fix your punishment. Is that correct?
Yes, sir.
You understand entering guilty plea and future convictions can be enhanced in a persistent felony offender law. You understand that, correct? That's your signature on the document.
Yes, sir.
Okay, now you also stipulate on the revocation, is that correct?
That's right, Judge.
Okay. I'll accept the agreement, order pre-sentence investigation report, schedule a sentencing on August the 27th.
Judge, we already have a bed for him at Spark. Would the court consider allowing him to go on to that?
I'm just going to have to do the PSI like I do on everybody else.
So he could appear for sentencing. They can.
No, we'll just do it like this, okay? You can talk to Commonwealth about it, but, you know, if you want to, but that's not part of the plea.
need to stay in the sentence.
But it's not part of the plea agreement. You know, hand that in.
Yes.
You know, we're,
This is on both, they're voting for the other probation.
okay, thank you. Thank you so much. Dustin Upfrey. Are you Dustin Upfrey? Good morning. This is 26 CR 0029. Mr. Humphrey, were you born in 1989? Last 4 digits of social security were 5636. You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done on probation and parole? Is it substantially correct? Is there any reason this gentleman should not be sentenced?
No, Judge.
Upon a plea of trafficking and controlled substance, first degree defendant shall receive a sentence of 70 years, serve 6 months, probated for 5 years. Probation is to be supervised. What are the court costs?
$220.
$220. I'll let you pay that at $40 a month, starting on 30 days after you get out, okay? Emmanuel Santiago Vega. Okay, there you go. Are you Emmanuel Santiago Vega?
Yes, sir.
We're on 21 CR 0042. You born in 1982. Last 4 digits of social security number 2451. Got a motion for shock probation. It's this older case here, Mr. Stock. What's going on?
Well, evidently he did pretty well, and then he got a DUI this year in Cumberland District Court. He was revoked on the DUI. He had slurred speech and all that, refused the blood test, but then he pled guilty to it on May 8th, Cumberland District Court. And he was revoked based on that, and now he's filed a motion for shock.
Judge, in our motion, of course, he's since been classified and he's working at the Class D facility now. That's why he's in a different clothes than the rest of them. We've asked in our motion for him to be considered for drug court. So I would ask that court enter an assessment.
Where do you work?
I'm saying,
Do what?
saying,
Just say.
Reminds me of what the late Fred Capps used to say, but I ain't gonna repeat it in court, but, he's got 60 days in. I think he would at least need to serve some more time before he got out of shot. Well, based on his
I
DUI.
mean, before we knew he was eligible for.
I know he's not parole eligible till April of 27, so his parole eligibility date is.
What kind of DUI record does he have in the past?
I'd have to go coordinate because we had to make up a new file. If I couldn't sign my file.
The underlying charge was what?
It's trafficking, controlled substance.
You remember what kind of?
No, Judge, we put our file in storage because it's an older case.
Yeah.
So
Well,
we
what I
made
wanna
up a
do
new
is
file.
take this under advisement.
Yeah.
And let y'all have an opportunity, to look at his file, see what kind of quantity it was, see what his DUI record was in the past.
Okay.
Couple of things that really bother me when people get out on probation or we probate them or shock probate them is they have a DUI or a weapon. One of my greatest fears is we let somebody out and they run over a school bus or run over some innocent portion if they've got a bad DUI record. And it seems like to me, it's not very much constraint, Mr. Santiago Vega, that you ought to be under to not drive a vehicle while you're on probation. I don't know. So we'll take a look at it. I'll take it under advisement. I'm not saying no, but I want to look into it a little bit before yes. Clay Smith. Commonwealth versus Clay Smith, 22 CR 0050. You are Clay Smith.
Yes, sir.
You were born in 1999.
Yes, sir.
Last 4 digits of Social Security number 3796.
Yes, sir.
You're here today for sentencing. You've got an opportunity to look at the pre-sentence investigation report under probation and parole. Is it substantially correct?
It is, Judge.
Is there any reason this gentleman should not be sentenced?
Judge, if you'll recall, we had a hearing or at least a pretty vibrant discussion on this case. Last time it was over alcohol use was, I think, pretty much the only complaint the Commonwealth had. We've got a bed for him at Spark. He wants to go to treatment. He knows he's got a problem he needs to deal with. I'd ask the court to consider allowing him to stay on diversion and not sentence him today, and allow him to go complete that program as part of his diversion.
You have a job anywhere?
Yes, sir.
Where are you working?
Bulls Construction,
Speak up a little bit.
Bulls Construction in Albany, Kentucky.
What do you do there?
I'm a carpenter.
I'm willing to go along with whatever the court wants to. I definitely think he needs to go to treatment before he goes back to work.
Judge, he's on the bus, he did last month, there's a work for job.
Yeah, I did an order avoiding the free trial diversion. I'm gonna set that aside. This is it for you, man. If you value your freedom and you don't want to be a convicted felon, you're gonna make this work. I'm gonna let them get you in a treatment situation, in-house sort of thing, not outpatient, okay? And y'all work with the Commonwealth to get someplace that's secure. You need, wherever it is, you need to stay there. You need to stay there. And I'm avoiding that, but I'm also taking it under advisement. So if you don't make it, I'm going to re-enter it. We'll go that route, okay?
And he'll stay in custody before he goes to the facility.
Stay in custody till then. Robert Tabor. Yes. Commonwealth versus Robert Tabor, 25 CR 0055. 25 CR 0043. Are you Robert Taylor?
Yes,
Tabor, rather. You
yes,
born in 1987.
yep,
The last four digits of your social security number are 3597.
yep.
Okay, now there's several motions. There's a pretrial conference, a motion to suppress in each one of these cases. What do y'all? Is that right?
Your Honor, we have an agreement on these cases.
I can't hear you.
Your Honor, we have an agreement on.
Plea?
Cases. Yes, Your Honor.
Okay, a felony plea?
Yes, Your Honor.
Okay. A motion's been tendered, sir, and we've identified you as having been born in 1987, or correct, so. A motion been tendered says you wish to enter guilty plea today. Is that correct?
Yeah,
Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given?
yeah,
Are you the same person named in indictment 25 CR 0043 and 25 CR 0055? Is that you?
yes,
Have you discussed this matter with your attorney, and are you satisfied with their advice?
satisfied as I can be, as satisfied as I can be.
Is your judgment impaired today anyway? Is your judgment impaired?
No,
Okay. Have you believe that you're fully informed about your case? Okay. Now, you understand that under the Kentucky United States Constitution, you're not required to enter a plea. You have certain rights under both of those. I'm gonna go over your rights with you. And at the end, I'm gonna ask if you understand, if anytime during this statement, you have any question, you can step away and talk to your attorneys. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses, all to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court if you lose, and the right to acquire the Commonwealth prove on a reasonable doubt that you guilty charge against you. Understand that by entering a plea of guilty, you give up all those rights. You understand that? Now, I may consider Commonwealth's recommendation, but I may apply any range of sentence gradable. I don't know, I don't have to accept their recommendation. In the event that I don't accept their recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea. You understand that?
yes,
Now, since you've been a state prisoner, is it going to be necessary to do a pre-sentence investigation report on this?
It will, Your Honor, due to the nature of the charges that.
Yeah, because of sexual offender charge.
Yes,
Okay. Okay, prior to accepting that recommendation, I'll await the sexual offender report and the pre-sentence investigation report. In the event that I don't accept it, then and decide to impose a harsher sentence than you've agreed to, then you would have a right to withdraw your plea. You understand that? What's the Commonwealth's recommendation, Mr. Gordon Anderson?
Upon a plea of guilty to rape first-degree vulnerable victim, the defendant shall receive a sentence of 15 years to serve. This 15-year sentence shall run concurrently with Monroe Indictment Number 25 CR 43 for a total of 15 years to serve. This 15-year sentence shall run concurrently with Monroe Indictment Number 25 CR 3. The defendant shall have no contact with the victim by any means. The defendant shall receive credit for time served. The Commonwealth opposes probation and shock probation. The defendant agrees to have any and all evidence in the above style case forfeited and destroyed in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that your understanding, Commonwealth's recommendation?
yes.
Are you pleading guilty because you did commit the acts charged in the indictment?
I don't know how to answer that.
Well, there's only one answer. You did it or you didn't do it. If you didn't do it, we'll have a trial. You've got a right to trial. I don't want you to be forced into doing anything that is against your conscience. If you did not do this crime and you want to stand trial, please schedule a trial. Okay. This is over then. And we will, y'all got your calendar with you?
Hold on
Hold on,
one second.
second.
Please.
I was,
Okay,
Can we speak with him, please?
Sure.
yes.
Judge, we're gonna continue with place.
You pleading guilty because you did commit the acts charged in the indictment.
Yes.
Okay. You're doing so of your own free will.
Yes.
Knowing your constitutional rights explained to us, it's 2 years out, you go forward and allow the court to fix your punishment within the range permitted by law. You understand after entering this plea, there are certain ramifications as far as future convictions and certain limitations as far as registration and that sort of thing, but you already gone through that on this other case you have here. Is that your signature on the offer?
Yes.
Okay, I'll accept that you're going to order a pre-sentence investigation report and schedule sentencing for August the 27th. And I kind of go look for an explanation.
The interplay in the two Monroe County cases also.
Yeah. You got the Monroe County cases?
We do, Your Honor.
Do I have them on the docket here? I don't see it. There's Monroe. Well, I read the Monroe County case. That's 25 CR 0043. I called it. Both of them.
We just read the plea for the Cumberland
Okay,
County
let's
case.
read the plea for the one in Monroe.
Read the plea for Monroe.
Yeah, this is Monroe Circuit Court meeting by agreement on 25 CR 0043. The court erroneously called 25 CR 0043, which is Monroe County case, along with 25 CR 00055.
Okay, so this is gonna be the Monroe, it's 25 CR 43 case.
Yeah,
Plea on it is upon a plea of guilty to rape first degree vulnerable victim, the defendant shall receive a sentence of 15 years to serve. This 15-year sentence shall run concurrently with Cumberland indictment number 25 CR 55 for a total of 15 years to serve. The indictment the defendant agrees that the offenses occurred after July the 15th of 24. The 15-year sentence shall run concurrently with Monroe indictment 25 CR 3. The defendant shall have no contact with the victim by any means. The Commonwealth opposes probation and shock probation. The defendant shall receive credit for time served and agrees to have any and all evidence in the above style case forfeited and destroyed in a manner that's consistent with the laws of the Commonwealth and the holding agency.
okay, we went down through all of the things. We're just gonna let that apply because I was talking about both of them. So it'll take some time to do the sexual offender thing.
Yes, I think we set it out to September. We could.
September the 24th, and you want it here, or you want it in Monroe County?
We have that in Monroe County.
Yeah, when's the date in September, in Monroe County? Got my. We'll find it out. Y'all know? Bring my calendar out here.
Excuse me, 17.
17th, September 17th.
Thank you, Your Honor.
Okay.
Judge, we need to submit the agreement to the court,
Pardon?
the paperwork to the
Yeah.
court.
It is your signature.
Yes, Your Honor.
Okay, Shane Vonsey. Commonwealth versus Shane Vonsey for arraignment. You got somebody have that. This is 26 CR 0041. Are you Shane Vonsey?
Yes, sir.
This is, were you born in what year?
1990.
Last 4 digits, social security number 3670. You have a right, you're represented by counsel, you have a right to make, what is that?
This is for
Fill out the rest of it, like, sign. Make sure you say it's in the. The grand jury of Cumberland County has returned an indictment charging you with the offense of second degree assault, one count, and another count of second degree assault. Do you understand? I'm not asking whether you did this or not. I'm just telling you what the charges are. You understand that? And then there's another charge of wanton endangerment, the first degree, 2 counts. Sheriff, will you present that to us? You acknowledge the identity of your client, receipt of the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, sir, Judge.
Mr. Stockton, do you want a negotiation day?
Yeah, we'll set one. It's not a complicated case.
Sure. It's on August the 14th. Next court date's on August 27th. Austin White.
Judge, could we address bond, Mr. Johnson?
Yeah, sure.
You got a $10,000 cash bond, Your Honor, he's not able to make that.
What's the charge?
He allegedly was shooting two girls on a bicycle with a BB gun and everything.
That's the basis for the assault second, because under the common law, that can be considered a weapon. So then he injured both of them. So I'd just be willing to get a speedy trial if you can't make bond.
You've been working for almost 8 years, Judge, at Cumberland Metals for Jacob Fisher. He's got a good job. He's got a place. He lives right here in Cumberland County. I don't think he's a flight risk, Judge. I don't think he'd be dangerous.
Well, if he did this, and I don't know if he did, he's a danger to society. And shooting at some girls and injuring them is something that the Commonwealth needs to look into, and you need to talk to him about if there's any possible explanation of this thing before I consider a bond. I will not consider this as a bond hearing. So you have the right to one bond hearing, and if you want to have a bond hearing, we'll set one. So you can present it and get something to ameliorate thing, okay?
Thank you, Judge.
Thank you very much. Austin White. Commonwealth versus Austin White, 26 CR 00018. Are you Austin White? Good morning. Were you born in 1999? Last four digits, social security number 8022. You're here for sentencing today. Have you had an opportunity to review pre-sentence investigation report about the probation and parole?
Yes, sir.
Is it substantially correct?
Believe it is.
Okay. Counselor, is there any reason why this gentleman should not be sentenced today?
No, Judge.
On a plea of guilty of theft by deception, over $1,000, you shall receive a sentence of 5 years probated, 5 years supervised. You shall enter and complete Cumberland County Specialty Court. Then it shall pay restitution in the amount of $7,700. Be payable to $150 per month to the Cumberland Circuit Court, first payment being due 30 days after entry of the plea. And 30 days thereafter, every 30 days until restitution and clerk's fee are paid, 5% clerk's fee. The defendant shall remain on active supervision through either the Cumberland Specialty Court of Probation until both of the following conditions are met: successful completion of the specialty court and payment of restitution in full. Okay. Has he been voted on as far as the
Yes,
court?
Your Honor.
And when will orientation be?
It's tomorrow at 1:00.
So do you have somebody that can come get you in jail in the morning?
Judge, he does have a holder out of Barron County. He goes to court there Monday. I expect and hope that case will resolve favorably.
What is that charge over there?
It's a theft charge, and I expect they'll probably piggyback on our condition of completing drug court. So it'll be next week before he can be released.
Okay, well, you'll have to set a new orientation date with the drug court. So we'll just, I guess they can turn him over to Thomas on their dime. We've already sentenced him here. So you need to tell him he's they'll probably move him to Barron County.
Yeah, I'll say so.
Okay. Make it easier for you to get him to court in Barron. Do they do Zoom?
They've been doing Zoom and bringing you over. They pick me up every time I go over there.
Well, that might be easier to get you transported over there.
They'll pick me up tomorrow, before they on Monday.
Okay, that'll work out then. Okay, thank you. Is that everybody that's been transported? Yeah, $185 court costs. You start paying it 30 days after you get out. $30 every 30 days to it's paid for. Is that everybody that you transported?
Yeah.
Take a break and y'all can move on out with the transportation folks, okay? Come on out this way. Stay off the, get off the record just for a second. Okay, let's go. Everybody in the audience, take your seat to these folks exit. Okay, let's go back on the record. Commonwealth versus William Brooks. William Brooks.
Ask for arrest and warrant, Your Honor.
Okay. Was he served?
He was out, he had just been shot out. And he tested positive a couple of times and he didn't report to Officer Garner, something. William Brooks.
Your Honor, I went to, did a home visit on him yesterday, not yesterday, before yesterday, and I left the door hanger with the occupants of that residence, and I asked him to call me when he got off work. He never called me, and I directed him to be at my office at 8 a.m. yesterday morning, and he never showed up. So I just haven't had the time to do the violation report for absconding and requesting a warrant.
Okay, we'll get the warrant. You go ahead and do the violation. Brett Carver. Commonwealth versus Brett Carver, 26 CR 0021. Y'all, Brett Carver. Get behind the podium here.
Yes, sir.
You born in 1976. Last four digits, social security number 5893.
Yes, sir.
Okay, what's the Commonwealth have to say?
Your Honor, my understanding was there was a $7,000 some arrearage which was paid. But during the meantime, there was another $2,800 accrued and that's been paid by check. And as soon as that clears the bank, I'll be entered order dismissed.
This is the child support, please,
Yes.
support. Okay. That'll be fine. Michael Clark.
Your
Yeah. Michael Clark.
Yes, sir.
It's 24 CR 0087, Commonwealth Kentucky versus Michael Clark. You are Michael Clark, born in 1987, last four digits, social security number 6073. Says for review, what does the Commonwealth have to say about this? What does the Commonwealth have to say about Michael Clark?
You just say. He is in the specialty court. He had pre-trial diversion. It expires in 2028. It's just set for review. Have you graduated? Yes. Yeah. It just needs to be dismissed, diverted. I've not had any problems with him since he graduated. Well, his diversion is going to end in 2028. You want to supervise him in 2028?
Yeah, let's just keep it under supervision.
Okay.
Like everybody else, because we don't want to get in this situation. Everybody finishes getting this.
Yeah, and I guess I was confused because it's set for review and I didn't know what was.
I understand.
Yeah.
Okay. You meet with probation pro officer right there, okay? Thank you. David Dupree. The active warrant out. David Dupree.
I guess we'll put it in CISs.
Okay. Stephen Eves. Stephen Eves. Good morning. Are you Stephen Eves?
Yes, sir.
This is 26 CR 0032. Mr. Eves, you were born in 1981.
Yeah.
Last four digits, social security number 5393.
Yes, sir.
So you're on the pre-trial conference. What's the Commonwealth have to say?
We made offer and I got a counter offer and I'm down to my lowest number, so I don't know if we need a trial date or not.
What's the charges?
Traffic and control, so we had almost a pound of methamphetamine delivered to his house.
What was off?
He's got tampering with physical evidence and the traffic, and he could get up to 15 years. My offer is 9 years to serve. To the point.
And that's right, we came, he made that offer when we met last week in our de facto negotiation,
Pound?
so.
We just see what a jury's gonna do. It's okay. All the test results and everything back?
Already.
We just need a little time because there's some not out of state witnesses, but they're kind of scattered across the state, the witnesses are. We got a postal inspector and Desi and the lab person.
What's the bond in this case?
$20,000.
And Judge, he's been in treatment since, since I've been appointed to him, and he's been doing very well. He's made all appointments. He's stayed in contact. He even, after a bit of confusion, showed up in Albany thinking he needed to be there for a
He
settlement.
did, he came to my office.
So
It was well behaved.
I would ask that he remain on bond as it is, but I would also ask the board to consider us to at least give us a month to consider this plea offer.
I'm finished with it. Here's the deal. I have sympathy for anyone that has a drug problem. And most everybody that has a drug problem ends up, trafficking in some way. Even if they give it to somebody else, which, or trade for somebody else. But pound, man, the problems that would cause this community, he's either gonna take the plea, which he didn't want to, we're gonna set a trial. Because the Commonwealth has already said that's the last and final offer, so there's no reason putting this out. He's lucky he's out on bond, Okay, let's set this sometime in September. What about, September 22nd?
I was going to tell the court because I'm unavailable on Wednesday, the 2nd and the 30th of September. I've got the 3 in between I'm available.
22nd, you're available?
No, I mean the 2nd and the 30th. I'm available the 9th, the 16th and the 23rd if you want to set it on Wednesday.
I don't want to set it on, this was on a Tuesday.
Oh, a Tuesday. I've got September the 1st as a Tuesday.
That's right. He said the 22nd.
Oh, the 22nd. I misunderstood. I'm sorry. Yeah, I'm fine the 22nd. I thought you said the 2nd, John. I'm sorry.
Judge, can we set him for the August, pretrial motion day, the 27th?
If you have any motions, you can file it.
Well, I'm gonna have a conversation with him about the plea offer, and there might very well be motions to file if that goes negatively.
Well, if you have anything to file it. I'm not gonna put him on the docket if there's nothing to file. If you have anything to file, I'll let you file it for that day.
Okay.
Okay, Commonwealth versus David Freeman. Commonwealth versus David Freeman, 26 CR 00015. Are you David Freeman? You born in 1980?
Yes.
Last four digits, social security number 3407.
Yes, sir.
We're having a pretrial conference. What's the Commonwealth have to say?
I believe we're supposed to have a felon plea.
Is that correct?
That's right, Judge.
Just been informed that you filed a motion that says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same individual that was just identified in 26 CR 00015?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Discuss these charges with your attorney. Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you?
Yes,
Do you
sir.
believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea, that you have certain rights under the Kentucky and United States Constitution before I can accept a plea.
Yes.
You need to know that you understand those rights, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to use the evidence. Right to call witnesses in your favor. Right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove without a reasonable doubt that you're guilty of the charge against you. Understand that by enter your guilty plea that you give up all those rights. You understand that?
Sure.
Now, I may consider the Commonwealth's recommendation, but I may apply a range of sentence provided below. I don't have to accept the recommendation. Prior to accepting your recommendation, I will wait the pre-sentence investigation report done by probation and parole. After reviewing that, if I decide not to accept the Commonwealth's recommendation to decide to impose a harsher sentence, then you have a right to withdraw your plea at the trial. What is the Commonwealth's recommendation?
Your Honor, Mr. Freeman's been charged with 3 counts of sexual abuse, first degree, Class D felonies. On 2 of those counts, he'll receive 2.5 years each to serve concurrently for a total of 2.5 years. On the 3rd count, he'll receive 5 years to serve. That will run consecutive with those other 2 counts to make a total of 7.5 years. He also will plead guilty to possession of a handgun by a convicted felon. He'll receive a sentence of 7.5 years. Those 2 sentences shall run concurrently for a total of 7.5 years. The Commonwealth opposes probation. He'll pay court costs at discretion of the court. The 9mm shall be released to Sean Green. All other evidence shall be disposed of in accordance with the Commonwealth of Kentucky.
Is that your understanding?
Yes, sir.
Okay. Are you pleading guilty because you did commit the acts charged in the indictment? Doing so of your own free will?
Yes, sir.
You know, your constitutional rights explained to us, it's still your, those rights, and we're pleading guilty to the charges and allow the court to fix your punishment within the range permitted by law. You understand that?
Yes, sir.
Okay, now, you understand that by any guilty plea, any future convictions could be enhanced on a persistent felony. Is that your signature on the motion?
Yeah.
Accept the agreement, order pre-sentence investigation report. Now, this charge does not require a sexual offender report, it does?
It does.
Okay. We'll schedule sentencing on October the 22nd, okay? You're in the custody of jail.
Judge, would you consider allowing him to remain out in
No.
custody?
No,
pending
not with a
sentencing?
handgun, no. In custody of jail. Jason Graham. Commonwealth versus Jason, you are Jason Graham.
Yes, sir.
Were you born in 1994?
Yes, sir.
Last 4 digits of your social security number 3322.
Yes, sir.
We're here on 26 CR 0004 for pre-trial conference. What's the Commonwealth have to say?
Pretty solid version, Judge.
I've just been informed that you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
I'm sorry.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 26 CR 0004?
Yes, sir.
Is your judgment prepared today anyway?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea of guilty, I need to know that you fully understand these rights. We'll go over them. Anytime you have any questions, step away from your turn. You have a right not to testify against. No one can make you say anything. Right to speed trial by jury. The right to be represented by counsel at your jury trial. Right to find false in all witnesses called to testify against you. Right to release evidence. Right to call witnesses in your favor. Right to appeal this matter higher court if it is. Right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering guilty plea, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply a range of sentence provided below. I do not have to accept the recommendation. After review of the report, well, I guess this is gonna be a debate here,
Yes,
so I won't have to do that. Let me just go over some qualifying points on your diversion. Have you previously been diverted in the last 5 years? Have you been diverted in the
No,
last
sir.
5 years? You have any felonies in the last 10 years?
No, sir.
Are you on probation now?
No, sir.
You have any, you understand if you complete the diversion program, your case will be dismissed, pretrial diverted.
Yes, sir.
Later have your record expunged. You understand that? You understand if you do not complete the diversion program, you will be brought back in front of the court. And if I revoke your pretrial diversion, we'll schedule a sentencing hearing, you'll be a convicted felon. You understand that?
Yes, sir.
And what is the Commonwealth's recommendation, Mr. Stocker?
Your Honor, he will plead to the charge of, amended charge of wanton endangerment first degree, receive a sentence of 5 years, pretrial diverted for 5 years. He will also plead guilty to a DUI first degree aggravating circumstances, receive 14 days in jail and pay a fine of $500. He is currently and has been enrolled in Spark for a while. He will complete and graduate that. At the conclusion of his treatment, he'll serve 45 days in jail, which will run concurrently with 14 days. He will pay a fine and court costs at discretion of the court, and all evidence in this case will be disposed of in accordance with the laws of the Commonwealth of Kentucky and pay court costs at discretion of the court.
Is that what you agreed to?
Yes, sir.
Do you realize that the DUI is enhanceable?
Yes, sir.
You're not doing a felony on the other case, so, but the DUI, if you get another DUI, it could be more severe penalties. You
Yes, sir.
understand that? Are you pleading guilty because you did commit the acts charged in the indictment as amended?
Yes, sir.
You, so of your own free will.
Yes, sir.
Nor your constitutional rights to explain who's still your desire to give up those rights. Enter a plea of guilty and allow the court to fix your punishment within the range permitted in the law.
Yes, sir.
Is that your signature on the motion and offer?
Yes, sir.
I'll accept it. What's the total court cost to be?
$1,150.
$1,150. You need some time to pay that.
Yes, sir.
Okay, I'll let you pay it $100 a month. And we'll do that upon the completion, start paying it on the completion of your jail time, okay? Okay, you need to be with probation and parole officer. If you leave Spark,
He's already completed
I've
Spark.
completed Spark. Okay, so yeah, you go into case.
going into custody then?
Yes, that's the agree.
Okay, custody of jailer. I thought he was going back to Spark, I'm
I didn't,
sorry.
I didn't know. He was.
Okay. Jade Jones,
Well, we'll have to put him or her in the house.
William McIntyre, Commonwealth versus William McIntyre, 26CR00040. William McIntyre, he born in 2005. Last 4 digits, social security number 6774. Is that correct? You're here with counsel for arraignment. You have the right to remain silent. The grand jury of Cumberland County has returned an indictment charging you with 14 counts of wanton endangerment. Charge you with discharge of a firearm across a public road. 1, 2, 3, 4, 5, 6, possession of drug paraphernalia and possession of marijuana. You understand those charges? Okay, Mr. Bailey, hand that to me. Counselor, you acknowledge the identity client received that away formal reading or amen or plead not guilty.
Yes, sir.
Is the negotiation date, Counselor? Thank you very much. You need a negotiation day on this?
Yes, Your Honor.
A negotiation date on August the 14th, the next court date on the 27th. What's his bond?
It's the med cash bond, Your Honor. I don't know.
What is his bond? Okay.
I think there needs to be conditions, no firearms in the house where he resides.
Yeah, you don't need to have any firearms on you, about you, any vehicle in your house at all. That's if it's at your home or somebody else's home. If it's there, you can't stay there for firearms there, okay? Okay, we'll see you then. April Nethery. Commonwealth versus April Nethery, 25 CR 0072, 25 CR 0073, 26 CR 0011. You are April Nethery.
Yes, sir.
Good morning.
Good morning.
You were born in 1981.
Yes, sir.
Last 4 digits, social security number 5139. You're represented by Greta Atherton, is that correct?
That's correct, John.
What does the Commonwealth have to say?
Your Honor, we have a case going to the grand jury this morning on Miss Nethery, so if we can set it for August the 14th, then in the next motion day.
You want to, we'll schedule it for August 14th for negotiation, and I've assumed that you'll inform council before then about
We
the
will.
indictment, so y'all can negotiate all of them on the same date over there.
We'll send her discovery on that case.
So discovery, I'll sign a reciprocal discovery order requiring that. April 14th, the next court date is April 27th. Both of them are conditions to your bond, 14th to 27th. You understand that?
Yes, sir.
Thank y'all very much.
Thank you.
Yeah. William Allison. Commonwealth versus William Owsley, 26 CR 0025. Are you William Owsley?
Yes, sir.
Good morning, Mr. Owsley. We were born in 1966.
Yes, sir.
Last 4 digits, social security 9744.
Yes, sir.
Represented by Mr. Bell on a pretrial conference. What we got?
Judge, I had called Mr. Stockton asking if we could have one more pre-trial, and I believe you agreed to that.
That's fine, Your Honor. I don't think me and Mr. Bell have had a chance to talk about this case.
Okay, August the 14th and August the 27th. Both of them at 9 a.m. 14th for negotiation, 27th for next court appearance.
Judge, could I just put the court on notice, the 27th, I have circuit trial set, but I don't know if it'll go, so I went ahead and put this down, but if it goes, I'll make sure to let Mr. Stockton know plenty of time.
Okay, we want to see some Zoom affirmation that you're actually there.
Yes, yeah, I'll do that.
Okay, thank you.
Thank you, Judge.
You have Barbara Parrish. Commonwealth versus Barbara Parrish, 26 CR 0022. Are you Barbara Parrish?
Yes, sir.
Born in 1989.
Yes, sir.
Last 4 digits, social security number 0985.
Yes, sir.
Okay, it was, this is a rocket docket case, is that correct?
No, Your Honor, it's just a plea on a possession of a controlled substance, first degree. It was set for trial
Just
August
keep
5th.
that there until I go over it, and then I'll ask for it. I want her to identify her signature.
Yes, sir.
A motion been tendered says you wish to enter guilty plea, is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
Yes, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Okay, you're the same person that we just identified in case number 26 CR 0022.
Yes, sir.
Okay. Have you discussed this matter with your attorney? Are you satisfied with her advice?
Yes, sir.
Is your judgment impaired today anyway?
No.
Have you reviewed the evidence Commonwealth has against you, feel like you're fully informed about your case?
Yes.
You have certain rights under the Kentucky United States Constitution. Before I can accept a plea of guilty, I need to know that you fully understand those rights. You have a right not to testify against yourself. No one can make you say anything. Your right to speedy trial by jury, your right to be represented by counsel at your jury trial. right to confront and cross-examine all witnesses called to testify against you, right to produce evidence or right to call witnesses in your favor. Right to appeal this matter to a higher court if you lose, and right to require the Commonwealth to prove on a reasonable doubt that you're guilty charge against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yes.
Okay, I may consider Commonwealth's recommendation, but I may apply your sentence provide law. I don't have to accept the recommendation prior to making that decision. I will review the pre-sentence investigation report. If I decide then not to accept the recommendation and impose a harsher sentence, you have a right to withdraw your plea of guilty and proceed to trial. You understand that? Mr. Stockton, what is Commonwealth's recommendation?
Ms. Parrish will plead guilty possession of a controlled substance, first degree, receive a sentence of 3 years, probated for 3 years. Probation be supervised. She'll pay court costs discretion of the court. She'll be evaluated by the SSC, follow all recommendations. She'll either maintain gainful employment or do 30 hours community service a week.
Is that your understanding?
Yes, sir.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
Doing so of your own free will.
Yes, sir.
Knowing your constitutional rights explained to this still your desire to give up those rights and allow the court to fix your punishment. Within the law.
Yes.
You understand that entering this plea, any future conviction could be enhanced as far as your range of penalty. Is this just a plea of possession? Is that right, Mr. Stockton?
I'm sorry, Your Honor.
Plea to possession?
Yes, Your Honor.
So it couldn't be enhanced by a previous felon?
No. It can be, if she gets a different type of felony that can be used. to-
Yeah, I'm talking about, she is a convicted felon, isn't she?
Yes.
Yeah. Is that your signature on the motion at all?
Yes, sir.
Okay. I'll accept the agreement and order a pre-sentence investigation and schedule the sentencing on August 27th.
There's a trial scheduled for August fifth, so.
It what?
Or it should have trial scheduled for August fifth, so we pick up.
Yeah, take it off the docket.
Thank you.
Yeah. August the 5th it was. I've got a Monroe County case scheduled for August the 5th also.
Yeah, that one's still on. Is that done?
Pickerel,
So, yeah, Hickory, yes,
Hickory.
that's still on.
Okay. But not good. Commonwealth versus Frederick Robinson. Are you Frederick Robinson? Good morning. This is 26CR0033, Commonwealth Executive versus Frederick Robinson. Mr. Robinson, were you born in 1973?
Yes,
Last four digits social security number is 0103.
yes.
We're here on a pretrial conference. What does the Commonwealth have to say?
No, I guess we may need a trial date. I don't know. I didn't really get a response.
What's the charge?
Oh, we will get you.
Did you?
Oh, that's right. Yeah, we have one more negotiation on this show.
Okay, if you want another negotiation day, August the 14th, and the next court appearance will be the 27th, it'll be at 9 a.m. here at the Justice Center on both those are conditions your bond, okay?
Thank you.
We'll then get it solved.
Jordan Scott. Commonwealth versus Jordan Scott, 26CR0038. Are you Jordan Scott?
Yes, sir.
Born in 2002.
Yes,
Last four digits, social security number 3365.
Yes, sir.
Okay, we're here on pretrial conference and an arraignment. Wait a second. No, I'm waiting to get the copy of it.
I was looking at that. Hey, it's all.
That's the same case that you guys seen. I wanted to bet thank you. Jordan Scott's case.
I'm confused.
Grand jury of Cumberland County, yeah, Roger Green saw, grand jury of Cumberland County has added a couple of that possession of controlled substance, first degree methamphetamine and possession of drug trafficking. You understand those charges? Acknowledge the identity your client received out by way of formal reading or in the interplea of not guilty, reserving all pretrial motions. Okay, now, Mr. Stockton, we have pretrial conference on 26 CR 0036 and two new charges. What you want a negotiation date?
Yes, Your Honor.
Negotiation date on August the 14th. Next court date on August 27th. The bond he has presently posted will stand good for these two new charges also. Okay, now we have a Clinton County case, Jada Shelton. Clinton County case, Jada Shelton, is that right?
Your Honor, this is my motion to continue. Trial day is set for next week. Ms. Shelton did not have notice of this, motion or court date.
Since this meeting over here, I won't hold it in contempt.
I mean, she didn't have any way of
Okay, no, you're
knowing.
good. All right.
But, on July 9th, the Commonwealth elected to proceed with what I believe it was 26 CR 39. I represented the co-defendant in that case, Mr. Purdue. And if that case is to go to trial at some point, I think she's gonna have conflict counsel. That's not a waivable conflict in my estimation. The other case that they did not elect, 26 CR 38, I don't know that. Is there a lab report or on
I
that
don't
one?
have a lab on that yet.
Well, okay,
That's the reason I didn't elect.
right.
Whatever the court wants to do. I made an offer of probation or diversion or something. She didn't accept it, so
What's the charge?
I think she's got a possession and a tamper.
And frankly, if the court will remember, I was a little. I advised her to accept it, the offers as it was, and I think with a little time, a little sit down time with her, perhaps I could get her to agree to that, and then
Well,
there would be.
what's the reason for the continuance?
Because in 26 CR 39,
The one we're gonna try.
the one that the Commonwealth elected, William Purdue was also charged. He's already entered a plea. And
Well, there's no conflict then.
it is because, I mean, her attorney has to blame him. And me being,
Well, it's
His
hard to
attorney.
blame somebody that's already pleaded guilty.
I just, that, the way they came up, they did not come up at the same time. I, of course, had Mr. Purdue over here on a case, and then he picked up Clinton. So we actually had him before I had Miss Shelton. And at that point, I didn't fully understand there was going to be a co-defendant until Miss Shelton came along. So I didn't go through the waiver process, but in my estimation, it's not a waivable conflict. What I would ask the court to do is to set aside, vacate this, and let's put her on the August dates and let me have a chance to meet with her and see if
Clinton
we
County you
can
talking
reach
about?
this agreement. Yes, sir.
And you're still gonna go ahead and get her conflict counsel, aren't you?
If I can't get an agreement, I'd like to have, before I go that route, I'd like to have one chance to.
Clinton Rule Day is on the 6th of July.
Yeah, 6th of August, yeah.
8-3 and 8-6, I believe.
That-
Right,
That's
6th of
correct.
August, I meant.
Yeah, we've got
6th
a
of August.
negotiation August 3rd and a rule day August 6th.
Okay, let's do the 3 and the 6, and then she doesn't enter a plea on the 6th, we can still schedule a speedy trial.
but we'll have to get conflict counsel, it's going to be
If
30, 39.
she doesn't
If she
enter a
doesn't.
plea, that's
Right,
then then you need to have conflict counsel.
which I'm sure the conflict counsel will just be jumping on board for a speedy trial. Yeah.
Everybody wants a constitutionally guaranteed speedy trials. Case on the 28th is continued.
You do know what say it's on the conflict.
Cheryl Silva. Commonwealth Kentucky versus Cheryl Silva, 26 CR 0034. Are you Sheriff Silver? Silva? Okay. Were you born in 1977?
Correct.
Last four digits social security number 8067.
Correct.
This is 26 CR 0034. You represent Ms. Stephanie Corm.
No, Your Honor. So Stephanie Gorham is my supervisor. I'm Tadra Fairclough. I represent Silva.
What's your name again?
Tadra Fairclough,
Tadra.
Yes, Your Honor. Taydra. Fairclough, F as in Frank, AIRCLOUGH.
Okay. Okay, we're here today for a pretrial conference. What's it Commonwealth?
We have a let's see. We have a misdemeanor plea.
Misdemeanor, please.
Yeah, it'd be facilitation of traffic.
Okay. I've just been informed that a motion's been tendered that says you wish to enter a guilty plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
No, sir.
Okay. Is this plea freely and voluntarily given?
Yes, sir.
You're the same person that we just identified in
Yes, sir.
26 CR 0034. Is your judgment impaired today in any way?
No.
Have you discussed this matter with your attorney and are you satisfied with her advice?
Yes, I have, and
Have you reviewed the evidence the Commonwealth has against you, but believe you're fully informed about your case?
Yes.
Do you understand that you do not have to enter a guilty plea? You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights.
Yes, I do.
You have a right not to testify against yourself, no one can say anything about speed trial, or jury right to be represented by counsel, jury trial right in front of cross examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in favor, right to appeal this matter higher court for the election, right to part the Commonwealth prove on a reasonable doubt that you're guilty of the charges. I understand about entering a plea of guilty that you give up those rights, okay? You understand that? Now, I'm consider Commonwealth's recommendation, but I may apply a range of sentence provided by law. I don't have to accept the recommendation prior to, in this, situation, it's a misdemeanor, so there's no pre-sentence investigation report. And if I decide not to accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea, seek to trial. You understand that?
Yes, sir.
Mr. Stockton, what is the Commonwealth's recommendation?
Upon a plea of guilty to criminal facilitation of traffic in a controlled substance first degree, she'll receive a sentence of 12 months, probated for 2 years, probation to be supervised. She'll pay court costs, discretion of the court. All drugs and drug paraphernalia will be destroyed in laws of Commonwealth, Kentucky. Samsung iPhone will be forfeited. Also, the Commonwealth filed a notice of Liz Pennings on her real estate. She'll have 24 months to pay $3,000, and upon payment of that, the Liz Pennings will be released.
Is that what you agreed to?
Yes, sir.
Are you doing so because you did commit the act charged in the indictment as amended?
Yes, sir.
Okay, you're doing so of your own free will.
Yes, sir.
Now, your constitutional rights explained to us is still your desire to give up those rights, enter a guilty plea, and allow the court to fix your punishment within the range permitted by the law. Is that right?
Yes, sir.
Okay. Okay, is that your signature on the document and offer?
Yes, sir.
What did the total court cost?
$200.
$200 plus the restitution. You need some time on the court costs, restitution?
Separate. So yes, sometime on the court cost, please, Your Honor.
Pardon?
Time on the court cost, please, Your
Okay,
Honor.
I'll let you pay it at $50 a month. The first payment starting 30 days today.
Now, do I pay the $50 a month and the $125 a month towards the
For
3,000?
4 months. And
Well, yes, I
then it
understand,
goes
but I
back.
can pay both things.
Yes, for the
In a
first
month.
4 months.
Okay. Yeah. Yeah. They're concerned, that's why I think they give animals.
Now, this, is this supervised or unsupervised? We'll need to meet with the probation and parole officer over here just for a second, okay? Okay,
May I have excuse, Your Honor?
yeah, where do you locate?
At Nicholasville, Your Honor.
Pardon?
Nicholasville, Kentucky.
Nicholasville, what's a lovely drive down here.
Yes, Your Honor.
Make sure you go, which way did you come down? You don't know, you got on
It's through
GPS.
Casey County and through Casey County.
127.
Yes, Your Honor.
You got on the parkway, came to Columbia and came down here. I
Yes,
hope.
Your Honor.
Didn't go across the dam,
I
127.
did not.
That's a lovely drive on the way back. I suggest that. Thank you.
Thank
for
you.
being
May I
here.
be excused?
Absolutely. Have a pleasant
Thank
day.
you.
Cody Stinson still in the hospital.
Yes.
Markia Vibert. Still active, worn out from Markia
I
Vibert.
believe she's here.
He's here, Judge. Okay, are you Markia Vibert?
sir.
This is 26 CR 43. Ms. Vivert, were you born in 1995?
Yes, sir.
Last four is your social security number 4120.
Yes.
Are you here for the purpose of arraignment? When we have heard that? Grand jury of Cumberland County has charged you with possession of controlled substance, first degree methamphetamine. Place to tamper with physical evidence. Possession of drug paraphernalia. And possession of marijuana. You understand those charges?
Yes, sir.
Bailiff? You'll give her that. You acknowledge the identity of your client, receive it out in my way form, reading it around the air, plead not guilty, reserve all pretrial motions.
Yes, Judge.
Okay, I'm signing a reciprocal discovery order. Now, she had not been arrested on the indictment warrant yet, is that correct?
Yes,
Is that right?
that is correct.
So you'll need to go, you'll need to be processed. Can you get somebody to process her, Mr. Bailey?
Yes, sir.
Okay.
I think we can watch the motion one.
There's not.
Also,
Yes.
Not that you missed anything.
You need to stay in the courtroom. You're in custody right now, and then they'll process you. What's your bond?
20,000 surety.
You'll need to have somebody make a bond.
What's her bond in district court, Tracy?
2,500. Yes.
She got 2,500 cash.
Cash.
I was in rehab and
It's not anything that you have done. This is a charge in a different court. So you're gonna have to make a bond. And she still have 2,500 cash.
I believe Miss Lucille Shiner posted it, and I'm not sure if she got that back yet. I don't think she did. That's correct. It's still posted as now, yes, sir.
Did the court consider allowing that stand?
I'll allow that stand. I don't know where she's been though. It's a little problem. Been in rehab, the reason you hadn't been served. Okay.
yes,
When you in custody, get processed, and they'll let you out on that bond. Okay.
okay.
Okay, I'm gonna take, is Wayne County on the line?
Did you give the dates for her? I didn't know.
Yeah, the dates are August the 14th for negotiation, August the 27th for your next court appearance. We're gonna do one Wayne County one, and then we're gonna take a short break. Wayne County, are you on there? This is Combo, Kentucky versus Lisa Dobbs, 21 CR 00105. Are you Lisa Dobbs? Okay, you need to turn the microphone on. Somebody needs to turn the microphone on. Go out and get somebody to come in and turn the microphone on for you.
Hello?
That's got it.
All right. Okay.
Carwell versus Lisa Dobbs, 21 CR 00105. Are you Lisa Dobbs?
Yes, sir.
Were you born in 1965?
Yes, sir.
Last four digits, social security number 5491.
Yes, sir.
What's the Commonwealth have to say?
Your Honor, this is a motion to revoke probation. She got a 3-year sentence on possession of controlled substance. And on July the 3rd of this year, she was in a single vehicle accident. I believe she was injured. She admitted to the officer that she had 4 shots of alcohol. She had a PBT of 0.14. She was taken for a blood test. She's had about 5 previous violations. My understanding is that she's going to stipulate.
Stipulate.
Judge, we can stipulate that she's been charged with DUI and, yes, we can stipulate.
Okay.
Okay, we'll tender an order.
Okay, I'm gonna revoke her probation.
Lisa, I'm gonna be down to Wayne County next week. We'll talk about this, okay? We're still gonna be
All right.
looking at rehab down the road.
All right, thank you so much.
Dare County, are you ready?
Yes, sir, we're here ready.
We'll just have 6 cases, so we'll just push them through. Commonwealth versus Louis Arms.
Louis.
Got an arraignment. You are Louis Arms. You born in
Yes, sir.
1904, last 4 digits 8381.
Yes.
Have an arraignment here to do, Louis, Mr. Arms. You have a right to remain silent. Your attorney's here. Grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance in the 1st degree, possession of drug paraphernalia, possession of marijuana, and illegal possession of a legend drug. Okay, Mr. Bailiff. Present that counselor, you acknowledge the identity of your client, see the indictment, wait formal reading and arraignment, enter plea not guilty, preserving all pre-trial motions.
Yes, Judge.
Okay, we also have probation revocations in 21 CR 0058, 21 CR 00137. We'll set a negotiation date for August 14th and the next court date on August 27th. You'll need to do a transportation order, Mr. Arms, okay?
Okay.
Okay, Mr. Arms, your attorney will be up to see you, okay?
Your Honor, did I get the court to call a case out of order? I've got at the bottom, I've got one at the bottom of the
We'll just have 4 cases. Which one do you have?
Boris.
Okay, Jacob Boris. Jacob Boris.
Don't have any to worry, thanks.
No.
Got an arraignment.
Cromwell versus Jacob Boris. 26 CR 0042 for arraignment, 20 CR 005, 20 CR 006. 17 CR 0029, 20 CR 005, and 16 CR 0077. You have a right to remain silent. You're going to be arraigned on this issue. Your attorney is present. The grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance, methamphetamine, possession of firearm by a convicted felon, tampering with physical evidence, possession of drug paraphernalia, possession of marijuana, failure to surrender revoked driver's license, being persistent felony offender on the tampering charge, persistent felony offender on possession of firearm charge. Mr. Bailiff, you presented. Mr. Cross, you acknowledge the identity of your client, receive the indictment, wait for more reading, and plead not guilty, showing all pre-trial motion.
Yes, Your Honor.
We'll do a negotiation date in this case
Needs to be.
on August 14th and the next court appearance on August 27th. Okay.
Thank you for taking that, Your Honor. I'll be back step. Jacob, I'll be up to see you.
Constance Cherry. Constance Cherry. Are you Constance Cherry?
Yes,
Were you born in 1995?
yes,
Last 4 digits, social security number of what? What are the last 4 digits of your social security number?
3111,
3191,
3111.
3111, okay. You're represented by Miss Atherton. You have a right to remain silent on the same. What's going on with this thing, Mr. Stockton?
It's the same, she's a co-defendant, Dylan Cherry.
And I have the same motion to release medical records in this case. And then after I get that, I'll be ready to set it for trial.
And I also filed a motion recording to bond, Your Honor, and I believe we set Mr. Cherry for another negotiation day on the 14th.
You know, 14th for negotiation and the 27th for next court date. What is her bond?
It's I want to say, is it 25,000 cash or property? I believe there's a note about property on this. Her family doesn't have a significant amount of property. For them, that would be a struggle.
What do you have, Mr. Stockton?
I'm looking, I don't have hardly any Kentucky criminal history. And I know we did an NCIC report, and I believe about all showing up is what she's currently charged with. Really, the basis for the bond, I guess, is the severity of these charges and the quantity of it. She doesn't have much criminal history, is what I'm saying.
What are the charges?
Well, she's got 6 counts of wanton endangerment of possession of controlled substance and criminal abuse, 6 counts.
I will say that the violence that is alleged isn't against
No,
Mrs. Cherry, that's against
Mr. Cherry allegedly assaulted the oldest boy with a steel-toe boot. That's the only additional charge. These charges emanating from the children testing positive for methamphetamines and the living conditions of the home.
Where are the children placed now?
They're placed with, I think it's Mr. Cherry's mother.
That's correct.
Does she have
Dixie
somebody
Diggs has
who makes a
custody.
surety bond?
She does, I think, but she asked me about a surety bond.
Where does she have a long residence here in Cumberland County?
I think they've lived here for a while. I believe they lived in Tennessee before this, but I'm not sure. Miss Cherry, how long have you lived?
Where you gonna live, Miss Sherry, if you get out?
Tennessee.
You know, that ain't happening then. Okay, wrong answer. We'll see you all those days, okay?
Thank you.
Okay. Tia Hancock. Twenty CR 0025. Are you Tia Hancock,
Yes,
born in 1992?
yes.
Last 4 digits social security number 2575.
2005, yes.
It's here on 20 CR 0025 for probation revocation. What's the time of it?
Your Honor, she has a case going to the grand jury today, so we can have the
What's she
negotiation.
what is it?
I believe it's a possession case. It's not.
If she wants a hearing today, I'll try to get one on this litigation.
No, I'd like to see what the grand jury does and see what we can do globally.
As much time as she sat in because we had a problem getting the report from the state police.
Okay, August 14th for negotiation, August 27th, the next court date. Okay, your attorney will be up to see you, and this time that you have will be a good time as far as any plea agreements.
Yes.
Okay?
I think she was terminated from drug court in the case, or she completed drug court.
Previously completed.
Previously completed. drug court.
Okay, your attorney will be up to see you, man. James Hurst, come up with James Hurst. Are you James Hurst?
Yes, sir, I am.
Morning. This is 22 CR 0013 and 22 CR 0038. Mr. Hurst, were you born in 1970?
Yes, sir, I was.
Digit social security number 2119.
Yes, sir, it is.
Case.
If you'll bear with me, Your Honor, I'll try to explain this case. Mr. Hurst has 2 cases, 22 CR 13, which is a T-Bud, 5 years. He has 22 CR 38, trafficking controlled substance over 2 grams, 5 years, for a total of 5 years. He was sentenced on those cases 10/27 of 22. During the course of his probation and shock probation, we've had to place him in NCIC 3 times. May the 1st, 23, 3/10 of 25, and January of 26. We filed 4 motions to revoke probation before he was ultimately revoked on 10/2 of 25. The court then granted shock probation on 11/12/25. He was supposed to enter and complete the Mercer County Drug Court. He absconded from that around 12/23 of 25. I've got medical records showing he went into the hospital on January the 15th of 26 for a heart cath. He was discharged on January 27th, January 17th, 2 days later. Basically, the records I've been furnished showed there was nothing wrong with him. They told him to go on a diet, quit smoking, and exercise was his treatment plan. And then,
Life sentence there.
yeah. And so he's absconded December, went to the hospital January. Then he went into rehab on his own on 3/25/26, which he was discharged from on 4/4/26, when he was arrested on the warrant from where he had absconded from drug court.
Judge, I'd like to ask my clients questions if the court would permit.
We need to put on testimony, I guess that's my question.
Stipulate.
I'll stipulate to that. I mean, we understand that to be.
Raise your right hand. Mr. Hurst, swear testimony you're about to give us the truth. Mr. Hurst, can you hear me?
Yes, sir.
Raise your right hand. You swear the testimony you're about to give us the truth, whole truth, and nothing but the truth.
Yes, sir, I do.
Lower your hand.
Mr. Hurst, so you were ordered to go to the Mercer County Drug Court.
Yes, sir.
And can you explain to the court what happened and why you had to leave the Mercer County Drug Court?
Yes, sir. When I got out of jail, I got extremely sick. I was in the emergency room 3 different times. The third time they admitted me. And actually, I was admitted on the 11th I was in the hospital for 8 days. My heart enzymes was very high, and they done a heart cath on me and cleaned. I had 2 blocked arteries, and they done, I guess, a rotary. I don't know what the technical term is for it, but while I was in the hospital, they got a warrant on me from drug court, and they actually discharged me because I hadn't been compliant. But I had been in the hospital for like over a week.
Which hospital was that?
I went to the emergency room in Hagen, and I was left Hagen, and they put me in Boyle County. Ephraim McDowell.
Okay, the Ephraim McDowell, is that the one where we got the medical records from?
Yes, sir. I think so.
And so Hagen, where is that hospital?
That's in Harrodsburg.
Okay, and so you were in Harrodsburg Hospital for how long?
I went into the emergency room. They actually transported me straight from there. They admitted me into Ephraim McDowell. I left Hagen that day, and they put me in the hospital at Ephraim McDowell.
Okay, and so you were discharged from drug court because you were in the hospital on the occasion in December, correct?
Yes, sir.
In
In January. I was going through my drug court proceedings, and then I'd actually took the paperwork up to the girl, me and my father did, and she said just keep in touch with her and let her know what was going on. So when they admitted me in the hospital, I got in contact with her, and my dad did too. And she said that she was going to try to get a Zoom visit, and she would do whatever she could for me, but ultimately they discharged me for not being compliant.
Okay. Now there was mention that you had gone to a rehab a little bit later. Can you explain how you got into the rehab and then what happened as to how you got out of the rehab?
Well, actually, what had happened was when I was in the hospital, when I was discharged from drug court, and the hospital released me, and I called ARC. I thought I better get back into recovery because that's where I wanted to be anyway. And ultimately, they took me in, but they would not take me back until my medical releases was complete, and that was up into March. And then as soon as they took me back, I went back to rehab, and I had come home on a 10-hour pass one day because they didn't even reset me. I went in clean, and the day I was arrested, I was clean.
Okay. And
so they put me right back where I was at ultimately, in as a OP status, the last phase.
Okay. You were in the last phase of your treatment at ARC?
Yes, sir. I made client of the week out of 500 people twice in 4 months.
Okay. So what happened with that program? How did you have to do that program?
I went out on a 10-hour pass to go see my father, and I'd come out of Walmart, and a police officer saw me and arrested me. And so ultimately, I've been here ever since.
Can you explain to the court what you are hoping to do in lieu of being revoked?
I would like to go back to ARC and complete the program. I'm trying to intern for them. All I can do is show them that I'm devoted. And after this little episode at the hospital, kind of scared me.
Okay. And how long was it that you were in ARC?
The first time I was in there 4 months, and I was supposed to see a cardiologist the whole time I was there, and I never did get an appointment. And I ultimately broke my foot. I didn't want to leave. I left because they had an intern, or one of the temporary guys was trying to tell me I was going to be not compliant because the orthopedic surgeon said I wasn't supposed to be on my foot walking, and that's a big campus. And I thought instead of getting kicked out, I would be better off to leave and call and let them know what was going on. I told my probation officer several times what my issues was, and ultimately, evidently, I did have a heart problem.
Judge, I'll pass the witness.
I don't have no questions.
All I'd say, Your Honor, is that from December 23rd to the day he was arrested on April 4th, there's no evidence he had any contact with anybody. He had an arrest warrant out that whole time. And I would say that whether the court revokes him or takes him off supervision, Mr. Hurst has proven over the last 4 years that he can't be supervised because it's like hitting a moving target. He goes to drug court, he doesn't police it. He goes into ARC and nobody knows about it. I mean, so I don't know how you supervise somebody like that.
Judge, what I would ask the court to do is permit him to go back to ARC. If the court wanted to increase his level of supervision, or, I mean, I know this is probably unusual, but if the court even wanted to put him on a GPS monitoring while he.
What about the NCIC?
Judge, I didn't address that with him. I think that two bases for the revocation today were the failing to complete the Mercer County Drug Court, and of course, the problem that he had with the rehab.
Of course, he was put in NCIC when he was coming from drug court, and he's been on NCIC on 2 previous occasions. So,
Judge, I would simply say if the court deemed it appropriate to put him on GPS monitoring.
You know, I've had all of this, the dog ate my homework stuff. Either he's seriously violated all the conditions this court's ever put on him, or he's the most unlucky person in the whole world. Everywhere he goes, there's some kind of conflict. And I'm just not going to deal with it anymore. He can go in front of the parole board as far as I'm concerned. Thank you very much.
Thank you, Judge.
Do you have anybody else in Adair County?
We have Pendergrass, Judge. Gary Pendergrass.
Gary Pendergrass. Gary Pendergrass.
Go ahead. All right.
Are you Perry Pendergrass?
Yes,
You born in 1989?
yes,
Last 4 digits, social security number 7964.
yes.
We're here on 26 CR 0030 for a pre-trial conference. Y'all have a plea,
Yes, Your Honor, misdemeanor plea.
misdemeanor plea. A motion's been tendered that says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person that we identified in 26 CR 00030?
Yes.
You need to speak a little louder, please. Okay,
Yes.
are you the same person?
Yes.
Is your judgment impaired today in any way?
No.
Have you discussed these charges with your attorney? Are you satisfied with his advice?
Yes.
Have you reviewed the evidence Commonwealth has against you? Have you?
Yes.
Okay, are you fully informed about your case?
Yes.
Okay, you understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm gonna go over them with you briefly. You have a right not to testify against yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to higher court if you lose. The right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. If after reviewing your recommendation, I decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. Do you understand that?
Yes.
What is the Commonwealth's recommendation?
Your Honor, Ms. Pendergrass will plead to the amended charge of unauthorized use of a motor vehicle first offense, receive a sentence of 120 days to serve. She'll also plead guilty to operating DUI first offense, pay a fine of $200, and she'll pay fine and court costs at discretion of the court.
Is that what your understanding of the plea is?
Do I get credit for time served?
yes,
Yes.
Okay. Yes, I do.
Are you pleading guilty because you did commit the acts and the charge in the indictment is amended? Are you pleading guilty because you did commit the acts? Yes. Okay. You're doing so of your own free will.
Yes.
On your constitutional rights, is it still your desire to enter the plea and allow the court to fix the punishment within the range permitted by law?
Yes.
You understand it, but entering a guilty plea on this DUI, it's enhanceable, and any future convictions could be enhanced as far as penalties concerned. Is that correct?
Yes.
Okay, bring me the document up here, and I'll show her signature. I'm gonna put your signature up on the screen here and let you identify it. Is that your signature on the document there?
Yes.
Okay, I'll accept the plea. What are the court costs? And
$850.
850?
Yes.
Okay, we need some time to pay that.
Yes.
Okay, are you, when you get out, you plan on getting a job or what are you gonna do?
I'm being held, I have to go to Tennessee and deal with something there, so I'm not even sure when I'm gonna get out.
They have a holder on her from Tennessee where she allegedly took the vehicle, Your Honor. That's the
Okay.
reason we did the misdemeanor.
Well, I'll just say when you get out of court here, when you get out on this charge here, you need to pay $50 a month. If you get incarcerated down there, you'll need to tell your attorney here and he can get a hold of the.
They're gonna come get her. She's already waived extradition.
I know, but after, she's gonna be in jail down there, okay?
Right.
So she'll start paying $50 a month after she gets out of jail down there. So pay the $50. I'm not, you can't pay it if you're in jail, right? Correct?
Correct.
Okay, so when you get out of jail in Tennessee, you'll need to be paying $50 a month toward your court costs and fines. Okay, thank you very much. We need to do the DUI paperwork on her. Can you get that done? Okay, thank you very much. It's Adair County. You have anyone else?
That's all, Judge. Have a great day. Thank you.
So thank you very much. Anybody else come before the criminal court this morning? Mr. Stockton, you have anyone else? Is that it? Okay, we'll stand in recess till 1 o'clock.
Diversion of it.
Yeah, where's the diversion doc? Y'all have any objection to anybody on the diversion docket?
I sent the orders today.
Okay, so you don't have any objection to
Yeah.
it? Okay, that'll be fine. What about the show cause?
It's on the yeah.
Okay, I'll come back out at 11.
Just, introduce you to the PSI runner.
Do what?
You guys said introduce you to the new PSI runner.
Yeah, where
He's in the other room next door.
I'll be right back out. Please back and get a moment of silence, please. Thank you. Everyone have a seat. Is there a child support docket today?
Yes, sir.
Shelton versus Shelton.
Judge, we're asking that matter be reviewed 22nd day of October.
Evers versus Jones.
Review 22nd of October, please.
Box Smith versus Box Smith.
The defendant is now caught up, asking it to be reviewed October 22nd.
Long versus Law.
October 22nd for review, please.
Sites versus Calgill.
October 22nd for review.
Norris versus Norris.
Same date for review, please.
And Cooper versus Cooper.
October 22nd.
Great.
I'll e-file those orders as well, so those.
Okay, electronically filed.
Yes, sir. Thank you, Judge.
We're a little early for the next docket. I'll flip down to see if the parties are here on it. We go ahead and take them up. Teresa Wade versus Cumberland County Hospital Association. Are all the parties here for that?
The hospital's here, Your Honor. I don't know if the plaintiff's counselor here.
Well, I'll come back to it.
You're not.
I guess we just better wait to call a docket for another 10 minutes. And let's go off the record. Mr. Hurt, could you step back here?
Yes.
Off the record. I'll come back and start in 10 minutes.
Good afternoon, Your Honor. Chris Brooker on behalf of the Cumberland County Hospital. Yeah.
Good afternoon. This is Laura Van Note for the plaintiffs.
I think when we were last here, we talked about doing some limited discovery on the issue of the application of sovereign immunity. Is that correct?
That's correct, Your Honor.
And that's all, and we came here today to review that. What's happened along those lines? I saw some of the motions here. It didn't seem like it went too well.
Yes, Your Honor. So after we were here 3 months ago to today,
Yeah.
we had a conference with plaintiffs' counsel about the limited discovery that you would allow the plaintiffs to take. To your instruction was that the parties were to get together and have the plaintiffs identify topics and submit parameters of the discovery, because the court recognized that in this context, discovery would be limited to the immunity issues.
Till we decide that issue at least, right?
Correct. And we invited the plaintiffs' counsel to submit a list of topics so that we could see if we could come to an agreement on what particular topics discovery would be taken on. We never then received any list. Over a month passed, and then we received the requests for documents in the interrogatories that we attached to our motion, which were extremely wide-ranging. They were the type of requests you would submit to any defendant in this case, whether public or private, that did not have an immunity defense. They were in no way, shape, or form geared to immunity. They went to issues of liability, negligence, standing, class certification. They ran the gamut. They were taking discovery on every aspect of the case. So what we did as the hospital is we answered those requests on any topic that in any way related to immunity, and specifically insurance. Because as a general rule under Kentucky law, county hospitals enjoy governmental immunity. They have governmental immunity unless there is a waiver by the General Assembly. And there is a waiver by the General Assembly when it comes to insurance. KRS 67186 provides that essentially, if there is a claim of negligence where a patient has been injured or hurt, there is a waiver of immunity in the context of county hospitals up to the policy limits. So what we did was we produced our insurance policies and the denial of claim letter that we received from the insurance company, where the insurance company denied the claims that we made, the hospital made, in relation to the lawsuits that had been filed. The hospital did not have cyber insurance policy that covered these claims, covered patients' claims. So it is our submission, Your Honor, as a matter of law, the hospital has immunity. There's no question it was borne by the county. There's no question it serves a governmental purpose. County hospitals have repeatedly, in cases, the Mormon case, the Fryman case, the Reyes case, been held to have immunity. And the discovery on insurance conclusively proves, which we have provided, that there is no insurance and thus there is no waiver here. So we're asking this court to go ahead and enter a dismissal of this case on governmental immunity grounds.
Counsel, would you like to respond to that?
Yes, Your Honor. I think that what we're dealing with here is a procedural problem. And, really our position is that this issue is not ready for the court to deal with it, and that defendant's motion was premature. So we had a conversation after the last hearing to make a plan for what we were going to do. We had discussions that obviously depositions are more burdensome on the county. And so we agreed that we'd start with written discovery. If the written discovery answered the needed questions, then we may forego taking limited depositions. My expectation.
What questions were not answered? Let's just get specific here. Say what questions were not answered that you think should have been answered?
Well, Your Honor, so the only questions they answered were with regard to insurance, and this is the problem.
I'm not asking you what they did answer. I'm asking you what you want answered. You have the list of, was that in your motion? Did you go down through?
The motion did attach the requests to it as exhibit.
Well, let's just, while we're here together, since there can't be an agreement on this. Does it start with the interrogatories? Is that where?
Yes, Your Honor.
Okay, well, let's just go down through the interrogatories. Is that on page 5 of your exhibit?
That's where it starts,
Yeah.
yes.
Let's just go down through these interrogatories and see. And I'll rule on them individually, since we can't come to an agreement on it. Okay. Number 1, identify and describe in detail all insurance policy you had at the time of the data breach and whether these policies cover the data breach. That was answered, correct?
Yes, Your Honor.
Yes.
Well, I want Ms. Thompson to answer because she's the one that wants to do things then, okay? Identify and describe how authorized third parties are able to gain access to your networking connection, the data breach. Obviously, that has nothing to do with sovereign immunity. You agree with that, Ms. Thompson?
It's Miss Van Note, and no. Council has presented the position that the only thing relevant.
See it up there. I'm sorry. I apologize to you. Okay, so
No problem.
interrogatory number 2 doesn't have anything to do with sovereign immunity, correct?
Yes, Your Honor, it does have to do with sovereign immunity. My position is that it's not just a question of insurance. Yes, insurance is important to this question, but the mechanism and the response to the breach is also relevant to the analysis. And we.
Okay, well, wait a second. I'm not just dealing with insurance. I'm dealing with the entire issue of sovereign immunity. Insurance is one part of that, but they could very well not be an entity that's entitled to sovereign immunity. Those are sort of questions that I wanted you to get to. So number 2 is describe how unauthorized parties were able to gain access to your networking connection with the data breach. Okay. Now give me a short answer about why that has to do with the issue of sovereign immunity.
Yes, Your Honor. So sovereign immunity may apply in situations where a entity that might otherwise enjoy immunity behaves as a business and not within the scope of the statewide purpose or benefit that the immunity is there to cover. Specifically, courts have dealt with cyber security and that not being part of sovereign immunity. So we need to know, how did they behave? Are they behaving as a business? And are they doing things that any business would do? Or are they behaving as a entity that's serving a statewide need? For example, providing medical care to patients. So we need to know what it is that they were doing and how they operated in order to know whether or not this really falls into the mechanism that they say provided some statewide benefit.
Okay, you can respond to that.
Your Honor, under the Coppage case, which is the test.
Speak up louder so she can hear you.
Yes, under the Coppage case, which is the test for governmental immunity under Kentucky law, there are 2 questions. First question was the hospital created by Cumberland County? The second question is the operation of a county hospital a key governmental function? The Kentucky appellate courts have already answered number 2 under Mooring and Fryman that the operation of a county hospital is a governmental function. Under the Kentucky law that governs this case, there is not a separation of functions, whether it be surgery versus record keeping versus any other aspect of work done at the hospital. It is the institution itself, whether it be a hospital, a highway garage, or a school. The entity enjoys governmental immunity if it passes the test of 1 and 2. And the discovery on interrogatory number 2 has nothing to do with the 2 questions from the Coppage case.
Okay, I'm going to rule it interrogatory, and we'll get this as the final and appealable order as we go down through these interrogatories here. Interrogatory 2, I'm going to rule it's not discoverable. Interrogatory number 3, identify and describe each category data stored at the time of your data program. I think it falls along with number 2. I'm going to rule it's not discoverable. Identify all individuals with non-public knowledge of data breach. I'm going to rule that's non-discoverable as to the issue of sovereign immunity. Interrogating number 3, identify all prior insurances before breach of data of all instances of unauthorized activity on your database. I'm gonna say that is not discoverable.
Your Honor, with regard to this one, we're asking whether or not there was a payment made, meaning did the insurance pay for these other claims? If the insurance company covered some other similar claim, that would tend to show that it might be applicable here.
Your Honor, we've provided the denial of coverage letter from the insurance company.
Well, this is a two-part question with a disjunctive and there. It asks for all prior instances of unauthorized activity on your network, and then whether the claims were paid regarding these prior instances. So that is, we have no insurance. Did you answer that one?
Yes, Your Honor.
Okay, that's been answered. Okay, so number 5 was answered as to whether or not you had insurance, but I'm not going to require you to say whether there was unauthorized activity. So that's a kind of, we're separating that. Identify individuals involved in any investigation. I must say that's not discovered. Number 7, identify and describe all efforts made by you to ensure the data practice comply with the relevant statutes. I'm going to say that's not discoverable. Identify and describe in detail all efforts undertaken you to contain the breach. I'm going to say that's not discoverable. Number 9, describe in detail how you became aware of the data breach. I'm going to say that's not discoverable. Number 10, identify and describe all outside cybersecurity vendors and legal professionals who you consult in connection. I'm going to say that's not discoverable. Identify all persons involved in investigation. I'm going to say that's not discoverable. Number 12 is number 13. Number 12 is identify and describe the documents upon which you relied in connection with investigation of the root cause. I'm going to say that's not discoverable. Number 13, identify and describe all remediation, and obviously that would not be discoverable. Number 14, identify and describe all persons that have knowledge of your cybersecurity practice existed prior. That's not discoverable. Describe and identify in detail all means you use on or collecting forensic evidence such as this and everything. Not discoverable. If you contend that punitive class members and or any of them have not experienced a concrete injury in connection with the data breach, say all facts, that's not discoverable. Identify and describe, including the name of all physical and email and all punitive class members contacted you in connection with the data breach, that's not discoverable. Now, interrogatory number 18, identify and describe all individuals sent to serve a notice of deposition, that's not discoverable. 19, you contend that the representing plaintiff is inadequate representation is not likely to get pursuit of litigation or the that's not discoverable. And number 20, you contend that the representing plaintiff possesses and brings in this case, which are typical of the punitive class, that's not discoverable. And number 21, you contend that the individual issues of law and or fact predominated over ones germane to the punitive class, how identified and described. I must say that's not discoverable. Now, I would ask one question. Ms. Van Note, are there other people, if the hospital has solemn immunity here, are there cases where vendors or other people, if they're under contract with the hospital, would have some exposure to
Yes, Your Honor.
Okay.
For example, most businesses rely on some outside companies to advise them and provide data security. And if there is such a vendor and that vendor didn't perform their functions properly and that led to breach.
Any of the vendors, have you named any of the vendors as party defendants?
Yes.
Okay, and so.
I'm not aware of any vendor being a defendant in this case.
I didn't see that.
No, we don't know who they are, is what I'm saying. We have to ask, that's a private matter. We have to ask in discovery who the folks are that are involved.
Well, I didn't see where you asked for any vendors.
Yeah, we did.
Which number is that?
So we asked for any individuals involved in, here, let me get specific for you. Identify all individuals with non-public knowledge of the data
What are you
breach.
talking about?
I'm sorry?
Laboratory number are you talking about?
Number 4, identify individuals.
Go to number 4, wait just a second. Identify all individuals, including sufficient information to serve a notice of deposition upon with non-public knowledge of the data breach. Now, nobody could have looked at that and supposed that you were asking for vendor information.
I think that does call for that type of information.
I'm not saying it doesn't, but I would just say if I read it, not being familiar with this sort of litigation, it wouldn't
Well,
have triggered me to think
and-
that. So what's your position? Is the sovereign immunity that you claim reach to all your vendors also?
I think the easy answer to that is we don't have vendors who do this IT. We have an in-house IT department, so that essentially moots that point.
Yeah, so I didn't know that. I
Yeah.
thought everybody had vendors when it comes to this. So you have internal.
Correct.
And so you don't have consultants who gave information or anything that might have be subject to liability?
Not at the time of the data breach. Now, after the data breach occurred, there were consultants to help with how you handle it. But before the data breach, there were not.
Okay, that gives you the information, Miss. That note, he said on the record that they didn't have any consultants or anything.
Well, I mean, setting aside that counsel is not testifying and the party needs to answer that information. I'm not saying I don't think it's true, but.
If the party had signed interrogatories, that would be sufficient to bind them. So.
That would answer that question in a way that I believe is proper.
Okay, well, I'm gonna order you to answer that interrogatory number 4 now that we know what Ms. Van Note was looking for there with more specificity. Okay? That'll give them that information to the other parties. So if you'll draft a order and circulate it to her for her approval to be consistent with my orders today and make it final and appealable. And that way, if I'm wrong about this, Ms. Van Note, y'all can proceed and my bosses up above will give me instruction to let me correct my error of my ways, okay?
Yes, Your Honor. Along the same lines, number 7. Identify and describe efforts made by you to ensure your data practices complied with relevant statutes. I would normally expect an answer to that to be, we hired such and such company to ensure.
Yeah, well, I'm gonna ask them to see if they hired anybody that might have any liability to you and might not fall under the sovereign immunity. And it's, that answer would be that you don't have any, right?
As far as I know, yes,
Okay,
Your
well,
Honor.
then you need to make sure you give her an answer on that with that specific certainty, okay?
Okay.
Okay, well, thank y'all very much for your time.
So just to be clear, Your Honor, we will be providing her an answer to that. And then did you ask us for an order as well?
I want you to draft a proposed order.
Okay.
Consistent with what I've ruled today to make sure we're all on the same page and circulate to her for her approval and editing, submit it to me and I'll enter it.
Okay.
The information I'm ordering you to give is whether or not you might have some other entity that you were under contract with that is a provider that might have potential liability for the breach.
Yes, Your Honor.
Okay?
Your Honor, just to make sure the record is clear, I think we need to address number 10. Identify and describe all outside cybersecurity vendors and legal teams, professionals with whom you consulted.
Well, I'm ordering to do that before the data breach. I don't think it's relevant who they consult with the active data breach.
Understood.
If I'm wrong about that, you can take me up on it, okay?
Yes,
Thank you
Your
very
Honor.
much. Y'all have a blessed day. Car tax lien portfolio versus Beth Miller.
Your Honor, Christopher Combs for KAR.
Okay. Are you Beth Miller? You stand behind the podium there.
Your Honor, I believe there's an intervening motion from a David Cross.
Mr. Cross, you have intervening motion.
Sorry, Your Honor, what case is this?
KAR tax lien portfolio versus debt.
Oh, I'm sorry, yes, forgive me, I was thinking about the, Mr. Parisian. Yes, Your Honor, it's my motion, and where we are, I think it's self-explanatory.
I can't find it here right now where we are. Here it is, okay.
Your Honor, the situation is as follows.
You need to speak up.
And may I get over? I am a judgment creditor of Dale Reasoner effective yesterday. We have been in the process of trying to get him served through long arm and warning order, and had a motion set previously, and we got flooded out.
Okay, well, look, how is he involved with this piece of property, gentlemen?
He's co-owner. And my goal is.
It's not. It's not. That's not.
Okay, is this not the
No,
is this not Reader?
no.
Okay.
So I was trying to get out here.
Well, somebody said David Cross, so.
Yeah,
I thought that's when we were on. Is this 26 CI2?
06.
Okay.
26
I'll wait on the next.
0006.
That's
Yeah,
probably where the confusion is then. I apologize, Your Honor.
Okay, let's go to 26 CI 0006 KAR tax lien portfolio versus Beth Miller.
Yes, Your Honor. Christopher comes for KAR. This is our motion for judgment order of sale. There had previously been a payment plan effective with an agreed judgment. However, that plan has been defaulted, and we're asking for motion for judgment order of sale.
Tax case that you already had. You already had the judgment on and you already had the amount on. And what do you have to say, Ms. Miller? You don't have counsel here today. What do you have to say?
No, sir, I just found out about this, the end of April. I had no knowledge of any of this. That's why I didn't attend any of the hearings or anything. They were sending everything to my old Arizona address, which they say they received from Cumberland County. I've spoke with several offices within Cumberland County. They all have my Kentucky address. So I never received any of these notifications.
Is this a tax lien case?
It is.
Yes.
Okay, well, the taxes weren't paid and they sold it.
The taxes were sent to the previous owner. I never even received the 2000. I bought this
Were
property.
these taxes that were not paid by a previous owner? Is that what they were?
I bought the property with Mr. Cross, in February of 23. The 24 taxes were sent to the previous owner. They were not sent to me. I had lost my mother and my son, and I didn't even pay attention or think about it. About
How
these
much
taxes.
is the judgment for?
Almost $12,000.
Okay, what was the tax? What was the tax? So
The principal amount was $1,500. That was $1,448.98.
and you're asking her to pay 12,000?
The total at this point, with the cost and fees and all of the other things that go along with it, Your Honor, is $11,578.
Okay, how much were the attorney's fees?
2,971 is what we're asking for, Your Honor. The cost of litigations where the thing, it's $6,723.24. And that is due to, let's see, I'm bringing up the affidavit.
The way it is.
Wait a second. You'll get your chance.
There were warning order fees, and all the other things that go along with the litigation.
How much were the warning order fees?
Warning order fees alone were over 400, looks like 460.77.
Okay, well, that's a long way short of the rest of it. Where are the rest of the litigation fees?
Master Commissioner referrals, $400. There are Liz pendants that we filed with county clerks, the fees for those, and title fees. Let's see, all the other fees that go along with filing the court cases and things. That's in that affidavit, a status of account with Exhibit C.
And the warning.
Wait
order
just a
would-
second, man. Well, you're gonna
I'm
get your
sorry.
chance, okay?
I'm sorry.
The master commissioner costs that we had previously set a sale for $2,821.71. And then there was a master commissioner sale review, $750. They entered into a payment plan, so all that had to be paid. However, the payment plan has now defaulted, so we're back to all of those costs have been added to it.
She says she didn't enter into any payment plan with.
Let me make sure. The payment plan agreement was with Beth Miller.
No, it was not.
You have a copy of it?
April 23rd, 26th.
You have a copy of it with you?
We
Yes, Your
talked
Honor.
about,
Second, man.
So that case was already set up for master commissioner sale, Your Honor, and that sale was canceled based on, I believe, the discussions that Ms. Miller had and Ms. Lawrence. So
Now, I've got the statutory authorized fees, and the major part of it is litigation costs. Looks like.
I mean, if she's wanting to enter into another plan or she wants to make that happen, at this point, I think our policy's always been that once that plan is defaulted or that doesn't go through the way it goes, that they would accept full payment.
Okay, break down the 6,723 for me.
Yes,
The
Your Honor.
litigation costs.
We have a master commissioner sale review with $750. There's $2,821 to the master commissioner costs, $400 for that's the filing fees.
Because you pay that if the sale is scheduled and then canceled, right?
Yeah, and he had already advertised for that, so we had to pay for appraisals and advertisements and costs that he incurred.
Yeah,
Or
okay.
she. I don't know if your master commissioner is a man or a woman. I apologize.
Doesn't matter.
And then you go up the affidavit there. They're about $200 for Liz pendants. There are.
Master Commissioner, is she still here in the building? She leave.
I'm not sure I can step out and see close because we've got a case coming up.
She's the next case, so hopefully she's still here.
We do a title reviews, title abstracts. We also do a broker. I think that's Your Honor has cut those costs in past. The broker fees, $500 is what we charge for that because that is costs that we incur. Filing costs go to the county clerk of $225.
Cancel the sale because Miss Miller came forward. Is that correct? Now you can talk now, Miss Miller.
yes, there was no binding agreement to pay this.
Well,
We discussed it.
I'll decide whether it's binding or not. Did you make an agreement with him?
No, we talked about it. And we decided on the 24th that to have me served because I went to find Mr. Cross to help me with this. And I went to the wrong attorney's office and went to Mr. Riddle or Little and spoke to him about it. And he told me to have them have me served. And so on the morning of the 24th, I never signed any agreement with them. We just discussed it. I told her I was going to see an attorney. On the morning of the 24th, I told her to have me served. And she said that she had already set that up the evening of the 23rd.
Who's she you're talking about?
Katie Lawrence, their attorney. but I never entered into
Okay, well,
any
the
agreement.
problem is whether you agree to or not, they have a judgment lien. I mean, they have a judgment now. They got a judgment signed that included all these different aspects. I don't particularly like this law that they passed about having to pay $11,000 for $800 tax, but that's the only way they get some people to pay it. You know,
Yeah, but Your Honor, I didn't know anything about this because they had sent all these documents to the Arizona address and
who's getting the mail at the Arizona?
nobody, they were returned. Every single document was returned.
Well,
Even
where's your tax bill sent from the local tax department?
It was sent to my Kentucky address. To this address.
And Your Honor, on the tax delinquency bill, there's an address of Albany Road with the zip code the house number 6368. That's a PO Box 1333. Which address is that?
PO Box 1333 was the Arizona address that was closed. When you
So, Your
sent all of these
Wait a
documents
second,
out there,
wait a
they were
second,
returned.
wait a second. What was the Albany Road address? What does it say?
6368.
Is that where that document sent to that address?
No.
No, Your Honor, that's the description of the property on the tax bill, but the taxpayer information is Beth Miller with the PO Box 1333. And so per statute, we have to send it to the address on record until we're notified of something different. And once we have that new address, we've sent it to her and she's been served.
All of Cumberland County, even the county attorney's office. I checked with every single office. They all had my Kentucky address. My driver's license is a Kentucky driver's license.
Well, the problem you got, even if they had served you at that address, this tax bill was still purchased. And these people have a right to collect the tax bill and litigate.
But they never sent any of the I'm sorry. I never knew anything about this.
Did you have a closing done on it to see if all the taxes had previously been paid?
I'm sorry, what?
When you bought the property, did you see whether there were tax liens on it when you bought it?
Yes, Mr. Cross took care of all of this.
Mr. Cross, were you involved in this?
And there,
Your Honor, I don't recall much about this. I mean, I really don't.
Hunter Sure is the one that sold it.
No, David, I don't do Mr. Sure's work. David Choate does his work.
You got him crossed up. David Choate is a lawyer over there.
I don't do Hunter's work. I haven't. I'd be very surprised.
Have you ever seen Mr. Cross before?
I believe so.
Well, I mean, I don't know. We're both.
You're in Albany?
Yes, ma'am, but there's two Davids and we're on the same street. And I don't do Mr. Sure's work.
And David Choate does all his work. So that's who you talk to.
I don't think so.
I spoke with Mr. Riddle and they said that
Did you buy the property off of
it was, it's the Mennonites in, Monticello.
I don't.
It's Mr. Little who you're talking about, not Mr. Riddle. Mr. Little is the attorney on.
Yes, he's the one, but then they said it was Mr. Cross is who did the closing.
Why haven't you obtained an attorney? Why haven't you got an attorney about that?
Because Mr. Little wouldn't take the case.
Well, there are other attorneys around. You can't go to one attorney and then not take the case and say, I'm not going to get it represented. It puts me in a very difficult situation here. The difficult situation is these people have bought a tax lien and they have served notice on the address that was with the PVA's office, your address there. And when you changed your address, you didn't notify the people.
I did notify
Well, it
twice,
didn't
in fact,
appear
3 times.
it's wasn't in their records over there.
I've notified him 3 times, even changed it when I paid my taxes last year.
Your Honor, if there was something that you wanted to do as far as set this out so she had more time to find another attorney, we can set this out for, some time. Just let us know how much time she needs.
Mr. Commissioner is here now.
Okay, great.
It's Beth Miller cell that previously had been set. There was a lit, you have the list of, so the cell was set and y'all stopped the cell? Move over, ma'am, so she can find the podium.
Yes, Judge, I'm looking through.
Let her behind, wait, get behind there, okay.
I'm looking through my email chains right now, and on April 23rd, I contacted Miss Katie Lawrence, I believe, who is an associate of Mr. Combs, and informed them that Miss Miller had contacted my office stating that she was not served with any documentation. My secretary, Alicia, had actually sent notice to the property here in Cumberland County. Miss Miller relayed to us that she had not received any documentation, and what we could see on the certificate of service showed everything going to her former Arizona address. She says that she was only notified due to the diligence from the Master Commissioner's office of sending out the notice of sale. And that's how she became aware of this issue that we currently have. The sale was then canceled the next day, where they asked me what would be the total cost for the cancellation of the sale.
And what would it break down the cost?
Judge, I do not have a
It
breakdown.
was $20-some $100.
That sounds roughly correct. I don't have the breakdown in front of me right now.
It was like $2,200 or $2,300.
Well, I'm gonna continue this out till next month, and allow you to try to obtain an attorney to go through your documents and see what possible defense on the service process you might have, okay? Not gonna order any sales today.
Your Honor, would you like a notice or order anything in that respect?
Do what?
Do you want a notice or order in that respect?
I do want one, and let's set it for August the 27th. That's the
Thank
next
you.
year. Now, ma'am, you need to be diligent in finding a lawyer. You can't go to one lawyer and he wouldn't take the case, and that makes it, this is not gonna go away unless you get an attorney that comes up with some legitimate reason why this judgment should be, the basic judgment should be set aside. And they'll have to look at the statutes to see whose responsibility it was to change your address at the PBA's office. You'll need to find some proof that you did that. That sort of diligence is what an attorney can do for you. But I'm going to give you an opportunity to do that because I believe you're sincere in what you're saying, okay? Okay, thank you very much. And if you'll, Mr. Combs, if you'll draft an order to that effect, send it in, I'll enter it, okay? Thank you very
Yes,
much.
sir.
Mail me that.
You what?
Will I get a copy of that now?
Well, you will get a copy when it's filed, but I'm telling you, you need to start now looking for an attorney.
Yes, sir, I
Okay, now.
understand that.
Okay, thank you. You'll get a copy of it. So there won't be any sale. Master Commissioner's here to heard this. And we'll come back and look at that next month. Okay, and you have it between now and then, you need to look at any diligent defense that you might.
Judge, I do have a breakdown of costs.
Okay, I don't need it
Okay.
now. Okay, thank you. Thank y'all very much. Okay, Everett Lake Holding LLC versus John Key.
Your Honor, Christopher comes for Everett Lake Holdings.
Motion to reschedule sale, or the Master Commissioner's here. What's that motion going?
I want to pull that up. I think this was another default payment plan, but let me make sure I'm not giving you the wrong information.
Are you aware of this, Madam Commissioner?
Yes, Judge, I believe he is correct. This was set for a sale previously, and I believe the defendant called and worked out a payment plan, and it looks like maybe he has defaulted and they are trying to bring that back.
Is that correct, Counsel?
Yeah, there was a signed payment plan agreement entered into the record around April 22nd. Mr. Key signed that.
Now you want to
There's supposed to be payments made every month, and
So now you want to reschedule the sale, correct?
Yeah, we'd like to go forward with the sale. There's been no payments since June. There was no payment in June, so he only made the two payments. So
How much
that
work?
those
How much-
payments should be
how much
reflected in the judgment, so I might have to redo that judgment for you, Your Honor.
So he just missed one payment?
He made a payment in April. He did not, and he made a payment in, looks like May 18th, he made a partial payment. And then there's been no payment since then.
So you didn't make one in June or July?
Correct.
Okay, schedule a sale. Okay, Everett Holding LLC versus Sharon K. Wolf, motion to confirm sale and distribute proceeds. Commissioner, you got the report on that?
Judge, I do not. I would just ask that the remaining balance be distributed because I did not see a place where Miss Wolf receives the remaining balance. Because I believe the property sold for roughly 61,000, so there should be a remaining balance due to Miss Wolf.
You agree with that? Mr. Combs?
Yes, Your Honor.
If you'll draft an order directing the master commissioner to distribute the remaining balance to Mr. Wolf, okay?
Yes, sir.
Okay, CML Tax Lien Company versus Weldon Parmley.
Your Honor, Christopher comes for CML. It's our motion to amend. It's come to our knowledge that Mr. Parmley has passed away as of July 8th of this year. So we're going to have to add heirs of his and unknown spouse of heirs of his.
Okay,
Yes, Judge, they had, Mr. Parmley passed away on July 8th, and they had their certificate of service showing that it was perfected on July 9th. And I contacted their office and let them know that Mr. Parmley was deceased and there was no way he could have been served on July 9th because he had already passed. So I guess now they're trying to move forward with the sale for the heirs.
nothing has been filed in district court.
Not that I'm aware of at this time.
Well, you might have to start at a creditor's administration or something in this case, if there's nobody to serve. Or either that, or you get another warning order attorney and look for his unknown heirs.
Yeah, that's probably where we're headed. I do have an amended order prepared, and we do have affidavits for those unknown heirs and unknown spouses of unknown heirs.
Okay, go ahead and proceed with that. I'm gonna try to get a warning order attorney on that, okay?
Thank you, Your Honor. That's all I have today. May be excused.
Thank you.
Have a great day. Actually, no, that's not true. We did have the initial KAR versus Dale Resner issue where Mr. Cross had filed a motion to intervene as the judgment creditor. We have no objection to that.
Okay. You want to prepare an order, Mr. Cross?
Your Honor, I have tendered an order and appreciate that.
Give it to the master commissioner, let her see it. You just want to read it and that way he can.
Okay. The record reflects that a judgment has previously been entered in this action in favor of the plaintiff as against the defendant Dale Reesner and his co-defendant Melody Williams. Master Commissioner of Cumberland Circuit Court has scheduled a judicial sale in this action for July 24th, 2026. On July 22nd, 2026, David M. Cross obtained a personal judgment in Cumberland District Court, case number 22C78, against Dale Reesner in the amount of $3,000 plus court costs. David M. Cross proceeded to immediately file a judgment lien against the defendant, Dale Reesner, identified as Dale Reesner Jr. in the current proceeding. Movement has indicated to the court his intent to execute by garnishment upon funds which might otherwise be due Dale Reesner after creditors' claims are paid and after costs and expenses of sale are paid. It might be in the possession and control of the Master Commissioner of Cumberland. At this time, it is unknown as to whether or not there will be excessive funds, as the Commissioner's sale has not yet occurred. A Master Commissioner is an officer appointed by the court primarily to carry out judicially ordered sales of real estate by foreclosure or indivisibility. The funds in the hands of the master commissioner may only be distributed upon orders of the circuit court. The movant cannot now claim an interest in the real estate, as the interests in the real estate have been determined by court judgment. The movant can, however, seek to enforce his judgment against assets of the judgment debtor. Adding the movant to the case as a party defendant will allow any proper and legal action by movant regarding collection of funds such as garnishment to be incorporated in the orders to be issued in this action. Therefore, the motion to intervene filed by David M. Cross is hereby sustained. He shall be designated as an intervening defendant in this action. Should the movant issue a garnishment against monies held by the master commissioner, which might otherwise be due the judgment debtor, then the master commissioner shall review same. And if the garnishment appears in legal order and there are funds which would be due Dale Reasoner, judgment debtor, then the commissioner file its recommendation regarding whether or not the garnishment or execution should be honored, and shall file a notice with the court and serve a copy upon the judgment creditor, who shall then file a motion for entry of an order of distribution regarding said garnished funds. No notice to the judgment debtor shall be required other than the notice required under the garnishment statute, KRS 425.501.
You don't have any objection?
No, Judge, I don't think a garnishment will be necessary. The property is set for sale tomorrow at 11 a.m. It's a price for $54,000. And currently, Mr. Combs and the plaintiff, they have a starting bid of $17,660.
Well, the garnish, the order will be necessary to give you authority to pay it, though. That's what the order-
And the word of explanation, we talked to the auditor for the
Yeah, I don't need
commissioners,
the
and they
explanation.
said we need to be a party.
Yeah, I don't. need
Your
that.
Honor, I think the only caveat would be that if he's not a priority lien holder, should there not be enough funds, and I don't really know all
I think
the
it says
math
that.
right now.
It
He
only
would maybe
says-
lose some of that. So that's his.
It already says that. It already
Okay,
says all of y'all's costs and everything be collected first, and if there are any proceeds available with the master commissioner for the distribution to anyone else that he gets
If
recognized.
there's any
as a
money
party.
left, I'm first in line.
Okay,
Thank you.
after everybody else.
Sounds
Okay,
great.
thank y'all very much.
Thank you, Your Honor. Thank you, Master Commissioner.
Yeah. Okay, now what cases do we have left here?
Here we've got Boer versus Shirley,
Wait a second.
and then there's.
Okay, Mitch Boer and Michelle Boer versus Shirley and Peyton. Okay, this is the case where you try to go on the Uniform Child Custody Jurisdictional Act, and I don't know whether that has, you do that on an intrastate matter. It's interstate, isn't it?
Your Honor, it is my understanding, and when I was Domestic Relations Commissioner for many years, several years, yes, it applies interstate or intrastate. It is,
I
it's
can't find that it applies intrastate.
the way we operated then.
Well, I know people operate a lot of ways. I'm trying to make sure there's statutory authority under that. But somebody wants it heard here. Who wants it heard here?
Mr. Boer,
Okay, and
and I don't know what Mr. Shirley wants. He's here and he's pro se. He may have an opinion.
do you care which county it's heard in?
I'd rather have it heard in Barron County, and
What connections does the child have in Barron County?
the mother actually has a lawyer that actually he put in to have it stay in Barron County as well.
Your Honor, the only proof would be his residence, the child, the mother, the grandparents all live up north of town here.
Child's been here its entire life.
Yes.
We'll hear it in Cumberland County. Okay.
Thank you, Ron. I'll grab it.
Do an order.
Do I need to refer to the UCCJA?
No, it's that, you deal it as you would if it was for a change of venue.
I will do so.
Okay, thank you. Thank you very much.
I've got your correct address, correct? Yes, sir. Thank you, sir. Here we go, Colwell versus Smith.
Where is that on the docket at? Wait just a second, let me find it.
It's the one before. Oh, we just heard.
Yeah. Okay, Allison Colwell versus Nina Smith and others.
Your Honor, Mr. Anderson's on Zoom. He represents part of the defendants. This is an indivisibility petition, pretty good house down at Ashlock, and I don't think anyone's opposed to the order of sale being entered, but I have to defer to Mr. Anderson about that.
There's no opposition to the sale, Judge. We just haven't been or seen a copy of the judgment with those terms. So we would just like to see that before the order is referred to the Master Commissioner.
I have tendered it.
You speak up a little bit.
I have let the Master Commissioner review it. We'll be happy to email you a copy today, Mr. Anderson. I don't
Okay.
think problem with it.
Okay. As far as the attorney fees, do you think, is that what we discussed?
I'll reserve it. The way we do it here is wait till the property sells and then we'll see what happens.
That sounds good. But I'm in favor of it being put in an
You'll have an
interest-bearing
opportunity,
account.
you'll have an opportunity to review the attorney's fees to see if they're appropriate or excessive. Knowing Mr. Cross, I'm sure they will not be.
Well, it's not even addressed in this order of sale. I've got that strange look on your face, Your Honor, I know, but
Yeah.
that's fine. And if Ms. Perigin is good with it, I'll send a copy to Mr. Anderson. We've got to pay the $200. Tracy, if we pay the $200 on this, we would not have them. So I'll get that paid tomorrow, and we'll.
The $200 gets paid whenever the order referring to the commissioner is entered. And just for Mr. Anderson's information, it
Speak
does
up.
look like there's $938.03 already due to a warning order attorney fee.
I'll take
Who is
that.
that? Who is that?
I'm sorry.
Who was the warning order?
Ms. White.
$900 in a warning
Well,
order?
there's several defendants, Your Honor. There's several. So unlike these cases where people want very excessive warning order fees, I didn't have a problem with it.
Okay.
Sometimes I complain.
So
It looks like they're maybe-
property's not under, it's just a division suit then, so the costs come off. Is it a significant piece of property for it brings some money or what?
Your Honor, I will tender the $200 and the order referring after I hear back from Mr. Anderson. And if you have any issues with that, let me know.
Okay, yep.
Okay, thank you very much.
That's all I have,
Sounds
Your Honor.
good. Thank you, Judge.
Is there anything else on the docket here? Do what? Let's see it then. We have a jury orientation coming in and where are they? Are they outside? Okay, Megan, if you're watching, bring me that